Ohio, Marshall Jonathan Carter, Jeffrey Collins, Jeannie Covelli, Trevor DeMint, Andrea Ellis, Denise Faulkner.
Jonathan Carter, I believe I've reviewed his file and it looks to me like he is completed, so I'll mark it completed. No further review date required. Jeffrey Collins. Is that Riverside? Oh, okay. He has not finished everything. His case number is 19-3004, 19-1082, 15-506. Will be a warrant issued for failure to appear. Jeannie Covelli. Case number 02-4667. Okay, do you have funds to pay? Do you have a payment today, ma'am?
No, I will have on next Thursday. We just buried my stepson.
Okay, well, I'm sorry about that.
Thank you. And I'll be making a $100 payment.
I'll set your next hearing for May 15th,
Thank you, sir.
9 a.m. Once you've paid it off, you can quit coming to these hearings.
Yes, sir. As soon as I get my income tax, that's what I'm gonna do.
Okay.
Thank you.
Trevor DeMint is here, 21-167, 2630, 2321, 19667, 19572. Good urine screen. Thank you, Trevor, for that. And a good report from OVP.
Yes.
Good job.
Oh, and third set me up to see the doctor about getting on something different too, so
Okay.
I stopped
Yeah,
taking it.
I sent that order out about gabapentin, and from what Dr. Davies, who teaches addiction science at the Marshall Medical School, tells me that's not, gabapentin and buprenorphine or Suboxone should not go together. So.
Right, I quit taking it, so they're going to meet with me and give me something different.
Okay. Can you pay anything on your fines today?
Yeah, I can make a payment.
How much?
Probably 20 or 30. That's it.
Okay, I'll put you down for 20. I'm going to set your next hearing. You are working, right?
Yes,
What's better, Mondays or Fridays?
Fridays.
May 26th.
Your Honor, if I may, he's been coming in twice a week doing urine screenings and they logged in, etc.
Okay, I'm going to make it once a week now
Okay.
instead of twice a week. And, let's see, you may have all your community service done.
I'm not sure if I even had any, but I talked about maybe coming in and could I do some community service to do some of my fines?
Well, I was going to say to everyone that's tomorrow, you can get $100 credit
Good.
by coming in because it's tomorrow Union Township Trustee or Fairgrounds. Okay. So come here at 7:30. You'll get hauled up to the fairgrounds, do some work up there. They're going to feed you. It'll be kind of like a big party probably. Plus you get $100 credit for your funds. Or if you need community service credit, you get 2 days credit for community service. You get double credit for tomorrow.
Okay.
7:30 tomorrow morning. Okay.
And the following Saturday.
And the following Saturday too. Both Saturdays you get double credit for community service. Okay, May 26th is going to be your next hearing.
All right, thanks.
You're doing good. Keep it up. Are you Andrea Ellis? What's your name, ma'am?
Faulkner, Denise Faulkner.
Okay, Andrea Ellis has been called, didn't appear. She gets a warrant for failure to appear. Denise Faulkner is 21-15-32. I've got a report from Riverside for you. Okay, it's not a good report, so I want you to do a urine screen this morning. Go do a
Yes, sir.
urine screen, I'll have you back out after I get the results.
Evan Holmes, Corey Milliken, Damon Pinckney, Chad Reynolds, Jeffrey Trout, Melissa Weaver.
Okay.
I'm here, Your Honor.
All right, Melissa Weaver, we'll go ahead and take you. Case number 16490, 09120, and 10251. Looks like you just have fines to pay. Where are you now, ma'am?
What is it?
Said the only thing you have left is fines to pay.
Yes,
And where are you coming in from? Where are you teleconferencing from home?
yeah,
And where is that? Where do you live?
Charleston.
Okay. Can you make a payment on your fines?
I did yesterday or the day before online,
Okay, how much did you pay?
$20.
All right, I'll set you for May 26th as your next hearing at 9 o'clock.
Thank you.
You're welcome. Evan Holmes. Evan Holmes is 220463. Has not completed. It's an OVI. There'll be a bench warrant for failure to appear. Corey Milliken,
Yes, sir.
220848. And you completed at Pathways, you paid your funds, community service.
Yes.
I think from the entry, it looks like you're required to go to the driver intervention program too,
Yes.
and that's the only thing you got left.
Yes.
Now, have you signed up for that?
I have not.
We've had a little bit of a problem. The agency that was doing it here locally is no longer going to be doing it. They're going out of Spectrum, they're going out of business. So the closest one now is in Scioto County.
Okay.
I believe we're going to have an agency try to be able to do that locally. They're trying to get approved to do that, or as of right now, I don't have a local option.
Okay.
I'm going to, since you've done everything, I'm going to give you a couple months before your next review hearing. If you get the 3-day program done in that time frame, you don't have to come back. If you go, you can go to the one side. You can go to any one that's approved by the state of Ohio. The closest one is in Portsmouth.
Okay.
If you need their contact information,
Yes.
Mr. Major has that
Okay.
in the probation office. You can probably go online and find others. The big cities have probably several
Okay.
there.
Okay.
If you want to go to Columbus or Cincinnati to go to one. Okay, I'm going to set your next hearing for June 30th. So that gives you over 2 months to get it done. Get it done, you don't have to come back.
All right, thank you so much, Your Honor.
You're welcome. Your name, sir?
Chad Reynolds.
Chad Reynolds. 2484 and 485 and 142166. I've got a report from Riverside. You've got a full-time job now?
Yes, sir.
And it looks like you're wrapping up the sober living part today. Is that
Yes, sir.
right?
Graduated today.
Congratulations.
Thank you.
It looks like the only thing you've got left with us is the, I'm showing 6 hours of community service, and that's it.
Okay, well, I'll get that completed then.
Okay, everything else looks like it's completed, so, what's your plan, even though you're, from the report, it looks like you're still involved with some other, like NA and AA meetings and
Yes, sir.
so forth, is that gonna be your plan going forward?
Yes.
Is to, how to stay in recovery?
Yes. Just
Okay.
gonna keep me doing the right thing.
Yeah, well, okay, I'll give you a couple months too. Get that last 6 hours of community service done, and then you'll be completed, and you don't have to come back if you do that.
Okay?
Okay, June 28th, I'm sorry, June 30th, June 30th. June 30th.
Well, I will have that done before then, so I appreciate it.
Congratulations, sir.
Thank you
You've
very
done
much.
well.
You have a good day. Thank you.
You're welcome. Okay, Damon Pinckney was cited to be here for review, has failed to appear, so it'll be a warrant, that's case number 161759. Same for Jeffrey Trout, was supposed to be here for a review, has failed to appear, has things left to do, so. Jeffrey Trout? Okay.
State of Ohio recalls Denise Faulkner.
Okay, your screen was appropriate. So, I want you to continue with Riverside and get a better report from them, okay?
Yes, sir.
I'll take a screenshot of, did you see your report?
Yes, sir.
Okay, and you'll put that in our file. Okay, we'll see you in a month. I'll make it May 26th.
Thank you.
You're welcome.
Tina Wells, Melissa Arthur, Nathan Boyd, Johnny Browning, Gregory Carlton, Denise Carter.
Tina Wells is 13,688, 14,1276. And you just have to pay off your fines.
Your Honor, if I
And also she has community service too.
I have a note that she was ordered on 3/24 to have some community service done for the next hearing, and she has not been here.
Okay, what say you about that, Ms. Wells?
Was told that you would tell me what all I owe and what I have, because I don't even know what I owe.
What's that got to do with you coming in for community service? You've got 5 days of community service.
Okay, well, I didn't know what I had to do.
I don't believe that. Okay, walk her up.
Lock me out.
That's not true. Melissa Arthur. Melissa Arthur Jennifer is 22,679. She hasn't done anything on her case, she gets a warrant. Nathan Boyd, 21,331. 2326 is not finished and hasn't appeared. You get a warrant.
I'm here, sir.
Oh, why did you say something? Okay.
Please don't give me a warrant.
You need to wave or say I'm here or something. Okay, you're at Lawrence County Recovery? Okay. You've been at Lawrence County Recovery in the past.
Yeah, I completed it.
Okay, well, right off the bat, it says, do not have a urinalysis to submit for this report. So, we need to do a urine screen. So go do a urine screen and we'll have you back.
Okay.
Go see Mr. Major in the probation office to get your urine screen.
He did one this past Wednesday, when I did the report. He hadn't done it yet, but the screen's in there.
Okay, I already ordered you to do one now. You can do one here too. Denise Carter,
Yep, that's me.
22,1001. You finished the driver intervention program
Yes, sir.
and you have fines to pay.
Yes, I plan on making a payment next week when I get paid. I plan on having it paid off within the next month.
Okay, I'll set your next hearing for May 15th.
Okay,
Pay it off before then, you don't have to come back.
okay, thank you.
Johnny Browning, 22,2612. Has not finished and he hasn't appeared, so he gets a warrant. Gregory Crawton, 21,1657. Okay, I'm gonna, he has a very small amount left, so I'm just gonna say it's completed, case is completed. Won't issue a warrant on that. Okay, we're gonna start arraignments now, so that is for new cases or old cases. If you missed a hearing or didn't do something you were supposed, it's alleged that you didn't do something you were supposed to, you'll get called with arraignments. This is, the purpose of the hearing is to tell you why you're here, what the possible charges are, or what the charges are, and possible consequences of those charges. If it's a misdemeanor, I'll ask you for a plea, which is your answer to the charge, and you have three choices. Not guilty, guilty, or no contest. Not guilty is the safest plea you can enter. It preserves all of your rights. And the rights that defendants have are to remain silent. You don't have to make any statements. You don't have to confess anything against yourself. But if you do make statements, it's all on the record. Whatever you say can be used against you. You have a right to have an attorney. You have a right to have one appointed. If you're facing jail time and you can't afford one, then you can get a court-appointed attorney. I'll have to ask you about your income if you want a court-appointed attorney. You have a right to bail. You have a right to make the state prove any charge beyond a reasonable doubt. If you enter a guilty or no contest plea, you're waiving those rights. Don't do that if you don't understand, you don't know what to do, if you want a lawyer, or if you want a trial. Any of those reasons, you should enter a not guilty plea rather than a guilty or no contest plea. Call the first case.
State of Ohio versus Andrew W. Robinson, case number TRC 23444.
You have a name that you need to be in the courtroom.
You're Andrew W. Robinson?
Yes, sir.
Mr. Robinson, the state's filed a complaint alleging April 22nd at 10:29 p.m. in Mason Township, you were operating a vehicle while you were under the influence of either alcohol or drugs, and so as you refused to take tests. State's alleging that if you're convicted, this would be your first conviction.
Yes.
So the maximum on that is 6 months in jail, $1,075 fine, and a 3-year license suspension. The minimum, if you're found guilty, is 3 days in a treatment program, $375 fine, and a 6-month license suspension. Do you understand that charge?
Yes, Your Honor.
You're also charged with failure to control your vehicle. It's a minor misdemeanor, maximum penalty is $150 fine. Do you understand that?
Yes, Your Honor.
Do you have any questions before you enter your plea?
No.
What plea do you wish to enter?
Guilty.
Guilty means you're admitting it's true, you're waiving your right to have a lawyer, to have a trial, to make the state prove these charges beyond a reasonable doubt. And you're admitting that the charges are true. You understand that?
Yes, Your Honor.
Okay, I'm going to accept your guilty plea, and I have a report from the officer, so I'm going to read that into the record. If you want to make a statement or explanation, you can after you hear what the officer said. You don't have to. It's up to you. Okay, the officer says, April 22nd at 11:24, I was dispatched by the Lawrence County Sheriff's Office with a potentially impaired driver and gives an address in Mason Township. Deputy on the scene advised vehicle was being pulled out of the ditch. When I arrived at 11:51, I saw Deputy Cochran with the vehicle. I spoke with him about what happened. He advised that the vehicle had been stuck in the ditch was pulled out by another vehicle that had been on the scene earlier. He further stated there were 2 occupants, one female, one male. He said when he initially arrived, the female, who was later identified as the registered owner of the vehicle, was in the driver's seat. However, at some point after he arrived, they switched. As I spoke with Deputy Cochran, I watched the vehicle creep forward 1 to 2 feet and then stop. I approached the vehicle and saw it was a Honda bearing a high plate JJM 3468. I made a driver's side approach and saw the male was sitting in the driver's seat. I asked the occupant what happened. The owner of the vehicle told me that they got stuck. I asked him how they became stuck, and the driver, who identified himself as Andrew Robinson, started talking. His speech was garbled. He had the look of a deer in headlights. He had watery, bloodshot eyes. Strong odor of alcohol was coming from the vehicle. He told me another car had been coming from the opposite direction, ran them off the road. Asked if the other vehicle stopped, and both stated that it continued on without stopping. I asked who was actually driving at the time it went off the road. Mr. Robinson told me that he was. I told him that Deputy Cochran stated the female was in the driver's seat when he arrived, and she responded with sorry. I told her that it was fine, but I was more curious as to why they had switched positions. Mr. Robinson appeared to respond by making some kind of unintelligible noise, but then became silent. The passenger finally said that he was driving, and Mr. Robinson agreed with that. Asked Mr. Robinson how much alcohol he consumed that night, and he said a few. Further question revealed he'd been drinking at a friend's house. Asked him to step out for purposes of ensuring that he was safe to drive, and he got out of the vehicle. He leaned on the pillar with his shoulder for support. While walking back to the cruiser, he drifted toward his vehicle, put his left hand on it for further support. I explained to him while we walked that I was assessing whether or not he was fit to drive a vehicle and to deem whether he was impaired. Asking him with that in mind if he still was standing by the statement that he'd been driving and lost control of the vehicle, and he reaffirmed that he was the one who had driven it into the ditch. I gave field sobriety tests. I asked Mr. Robinson several preliminary questions. He told me that he had contact lenses in, that he was only taking antacid medications. He also considered himself to be in good overall health. Did not have any history of head injuries. Now that he was separate from the vehicle and the other occupant, I could still detect an odor of alcohol coming from his breath as he spoke, and it's quite strong. I observed Mr. Robinson's pupils to be unequal in size. He stated that was from something in the past. His eyes tracked equal and resting nystagmus was not present. I observed 6 clues for impairment on the eye test: lack of smooth pursuit in each eye, distinct sustained nystagmus, and onset of nystagmus prior to 45 degrees. Began the walk and turn test by attempting to have Mr. Robinson stand in the starting position. He started the test too soon, told him to start again, and he again tried to have him stand in the starting position. However, he moved his foot almost instantly each time he would stand heel to toe. And given how much he was struggling, I had him stand as he would normally until it was time to begin. I began, explained and demonstrated the instructions. He told me he understood. Once he finally began, he took 2 steps down the line, both of which were well off the line and were not heel to toe. Used his arms for balance, asked him if he was finished, and he was silent for a moment, trying to articulate something, then asked for clarification on instructions. I moved again along to the next task. There was 5 clues for impairment: starting too soon, moving his feet for balance, raising his arms for balance, stepping off the line, and not touching heel to toe. On the one-leg stand test, there was 3 clues. He picked his foot up, started the test after just telling me that he understood. I did not tell him to start. He also swayed even when he was standing with both feet on the ground. After he began, he put his foot down for balance in 6 seconds. He swayed and used his arm for balance. He was given a portable breath test and tested .224 on the portable breath test. I placed Mr. Robinson under arrest for OVI. He was handcuffed, Mirandized, and searched prior to being placed in the patrol car. He was given the BMV 2255 form. He elected not to provide a breath sample. He was transported to the residence and released there. It looks to me like you had some sort of alcohol-related offense in Hanging Rock Mayor's Court.
Yeah, that was just an open container that was in the car.
Okay, is there any further explanation that you want to make?
No, sir, other than I shouldn't have been driving that night.
I agree with that.
Yeah.
Okay. I'm going to hit you with a $1,000 fine. That's my policy if you refuse to take tests, and you
Yes, sir.
refuse to take the breath test, so you're getting a $1,000 fine because of that.
Understood.
Order you to pay the court costs. You'll have a 6-month license suspension starting April 22nd.
Okay.
20 days in jail, and I'm going to suspend 17. So I'm going to require that you do 3 days in jail because you had such a high portable breath test and it was obvious that you were extremely intoxicated. 22 portable breath tests, and those are pretty accurate.
Yes, sir.
I ordered you to do 5 days of community service. You have to go to the driver intervention program. As I said before, there's not one locally now, but I anticipate there will be one shortly. I don't know how long that'll take, but within a couple of months, there should be a local driver intervention program.
Okay.
2 years of probation. His review hearing is going to be December the 8th. The people that were here before court started, that was review hearings. And if you finish everything, you don't have to come to those. Those are just hearings to make sure you do what you're ordered to. If you get it done before your review hearing, you don't have to show up.
Sure.
On the failure to control your vehicle, I'll impose a $20 fine.
Okay.
Okay, now, is there any reason you shouldn't go ahead and do the 3 days right now?
Not that I can think of.
Okay. All right, I'll command them into custody. You can start your 3-day jail sentence now.
State of Ohio versus Lee Kip, case number CRB 23-211.
Sir, are you Lee D. Kitt?
Yes, sir.
Mr. Kitt, there's been a complaint filed alleging that on March 25th of this year in Union Township, you recklessly violated a protection order. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
It would help, yes, sir.
Do you have a job?
No, sir.
You have no income?
No.
I'll appoint Mr. Stratton to represent you.
Yes, sir.
Yeah,
Mr. Stratton is here.
yeah, Your Honor, we have
We
a
have
current
a
case pending before the court.
Oh,
restitution
okay, you're
case.
representing on another matter?
Yes. Yeah.
Is that set today?
No, it's
No, sir.
not.
No, the 20-something next month.
Good, yeah. On that,
15th, I think.
yeah, and on that case, I think we're just paying restitution.
Yes, sir.
Yeah, that's
Yes,
all
sir.
we're doing on that case.
Well, let's set on the 15th of May. is that-
Yes. Yes, sir.
All right.
Okay, you want to set this for a pretrial the same day?
Yes, Your Honor.
All right, May 15 will be the pretrial on this case. Now, apparently there is a protection order already in place. You cannot violate that any further.
Yes, sir.
I don't want to prejudge this case, but whoever that person is, well, Ann Kitt, same last name.
Yeah.
So that's your mother,
Yes,
correct?
sir.
You got to stay away from her.
I had no problem with that, Your Honor. I asked that he
You
be
don't live
allowed.
in the same residence.
We live about 200 yards away from each other.
Okay, well, you have to avoid contact.
Yes, sir.
Yeah.
Does that fall under her jurisdiction too? Does she have to avoid contact with? No.
No, I haven't ordered her to do anything. I've ordered you to stay away from her.
Yes, sir.
So if she comes around you, you retreat. You've got a separate residence, right?
Yeah, she beats on my door.
Okay, well, then you say, get away, Mom, you got a protection order, and you get on the phone, you call the sheriff's office and say,
Yes, sir.
my mother is here violating the protection order that she has against me.
Yes, sir.
Don't handle it yourself.
Yeah.
No, sorry about that.
I'll have a suggestion for you. Just.
Yes, sir.
He can sign a $1,000 signature bond. Next hearing is May 15th, 10 o'clock.
All right, thank you, Your Honor. Let me talk to you.
Yes, sir.
State of Ohio versus Tyree Samuel, case number CRB 23254.
Sir, you're Tyree Samuel?
Yes, sir.
All right, Mr. Samuel, there's a complaint, which I believe you have, that alleges that on April 26th of 2023 in Fayette Township, you not only caused or tried to cause physical harm to Cassidy Tyree, and that Cassidy is either a member of your family or a member of your household. So that's what makes it domestic violence. Domestic violence, as charged against you, is a first-degree misdemeanor. That means the maximum you face is 6 months in jail and a $1,000 fine. That's the most the court can impose if you're convicted. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
No, sir.
Are you going to hire a lawyer?
Yes, sir.
Okay, how much time do you need to do that?
I have a phone call with him after this.
And who are you planning to hire? Do you know who that is?
McCown.
Mr. McCown? Okay. He hasn't given you any dates when he's available, has he? Has he? Okay.
I have a phone call with him after this.
Okay. I'm going to set it for May the 8th as your next hearing. And is there a protection order request?
Yes, Your Honor.
Is it any problem for you to stay away from Cassidy?
No, sir.
Okay. You have to do that while this case is pending. You've got to bond up, so your bonds continue that you already posted. You order to stay away from her. That's what you're going to sign now, and get a copy of that, and then take it to me. She'll give you a copy after you sign it, and I sign it. Then take it to Mr. McCown. It basically says you're not to go within 500 feet of Cassidy while this is pending. And also, do not post things about her on social media or text her, no contact. Just so we want things to calm down. We don't want any further alleged incidents. Okay, I'm setting it for May the 8th as a pretrial. You need to tell Mr. McCown that. If that's a bad date, he'll contact the court about setting a different date. You come back whenever he tells you.
Okay.
Any questions, sir?
Yes, sir.
Okay, that's all. May the 8th, 10 o'clock.
State of Ohio versus Daniel Craig Collier, case number TRC 23448, A, B, and C. Daniel Craig Collier.
Daniel Collier. Daniel Collier was cited to be in court today at 9 a.m. It's after 9.
Your Honor, I think that I heard you talking about A, B,
Okay.
and
All right. He may have went to OVP for detox, so I'm going to contact them to see if they have him in their custody. So I'll pass this file for now until we get something back from OVP, whether he's in their facility or not, so the case will be passed.
State of Ohio versus Jennifer Stapleton, case number CRD 2162, CRD 181240, TRD 183524, and TRD 173143, A and B.
All right, Jennifer Stapleton is here today. It looks like you had a rehearing Monday on these cases. So.
Yes, sir. My mom broke down on the way to get me.
Okay, you didn't have to wait a court, is that what you're telling me?
Yeah. I did call in and let everybody know.
Can you make a payment today?
Not today, but I can bring you something maybe later on this afternoon if my boyfriend gets off in time, or maybe next week. I have to wait on him to get paid.
I'll set it for May 15th
All right.
as your next hearing.
All right, thank you.
I'll cancel the warrant.
All right, thank you.
State of Ohio versus Torrey J. Baker Jr., case number TRC 20-2078, TRC 20-1647, A, B, and C.
All right, Torrey Baker is here today, and your hearing was actually last week, it looks like.
Yes, sir.
You admit or deny you missed that hearing?
I admit.
Do you have an explanation?
No, sir, I have no excuse. I just didn't realize it was last week.
Okay, you've done your community service, you're just paying your fines. Do you have a payment on fine today?
Yes, sir. When I get paid today, I'm going to pay $100 on it.
Okay, so that'll be 4/4?
It should be around, it's usually around noon. So.
Okay, I'll put you down for that, and I'll set your next hearing for Friday's better.
Yes, sir.
May 19th.
Sounds good.
May 19th is a Friday. That'll be your next hearing, pay it off, you don't have to come back.
Cool, thank you.
State of Ohio versus William Gullett, case number CRA 0972.
This is a case that had been set Monday for review. And I do have a report from Riverside dated April 22nd. Okay, it's a pretty good report, so acceptable. You've got community service that left to do.
Yeah, I was paid on my fines here.
Today you did? Yeah, I see $50. Okay. You can get double credit by coming out tomorrow to do community service. You got 5 days left. And next Saturday also.
Yeah, one of them here, you know what I'm saying, I'll try to get over here and do it, you know what I'm saying, because working 12 hours, you know what I'm saying, working now, you know what I'm saying, working 12-hour shifts, it's kind of from 7 in the morning, or 7 at night till 7 in the morning, you know what I'm saying, kind of, that time in the morning, it's kind of rough getting over here, you know what I'm saying.
Okay, May 26th is your next hearing.
Okay.
I'll cancel the warrant.
Thanks a lot.
You're welcome. Okay, that finishes the arraignments that we have. Do we have any more coming? There's some in jail items. So we'll start the pretrial docket. Mr. Cummings is here ready to go with his.
State of Ohio versus Nathan Dawes, case number CRA 23154, DRC 23245, A, B, C, and D.
We need the prosecutor to come in. Set for pretrial today.
Your Honor, once Mr. Hill gets in and gets settled, we'll ask the approach on this one.
Okay. Nathan Doss.
Nathan Doss. May we approach, Your Honor?
Yes. Where's he gonna go? Okay. So we'll just do this. Okay, Amanda Rayburn texted me this morning. She might be well. That's ROBBINS, right?
Yes, Your Honor.
And he's at, you think, the local VA inpatient program?
I don't know, I don't think it's local. I think they sent him maybe to Pennsylvania, or it was off somewhere.
Okay, on, back to Nathan Doss, it's my understanding it's going to be a change of plea.
That's correct, Your Honor. We'd enter a no contest plea, stipulate to a guilty finding, and ask for sentencing to be delayed to allow for some treatment.
Okay, and the state's agreeing that this should be treated as a second offense because one of the other priors was a court not of record.
That is correct, Your Honor, according to our research of the matter.
And Mr. Doss, do you agree with what your attorney is representing?
Yes, sir.
So what I'm going to do is, my understanding, you're going to seek some treatment mean, it would be required on second offense in any event. So also, there needs to be substance use as a part of the treatment that he seeks in addition to any other issues. So I'm going to allow you to do that, and then I'll sentence you after I get the results of your reports of your treatment. And the better you do in treatment, then I've got some leeway on what I can do in the sentencing. You know, my goal is that you address the underlying issues and don't have this come up anymore, that you're not going to be operating a vehicle. At the very least, you're not going to be operating a vehicle impaired any longer. And if there's a further issue with substance use in your life, that you address that and on a permanent basis. That's what I'm hoping for. That's the evidence that I want to see. I need to be convinced of that. If I am convinced of that, then I can be as lenient as I possibly can be. There's a floor to what I can actually do. So then there's a pretty big leeway on what I can do on the top end if I'm not convinced. You know, if I feel like you're not taking this seriously and not going to treatment, I have quite a bit of leeway in what I can impose as a sentence. So I would suggest maybe 6 weeks or so to let him start the process and then come back, and I need to have some feedback from whatever agency you go to as to what they're doing with you and how you're making progress.
Yes, sir. Be fine, Your Honor.
So I'm looking at probably second week of June sometime. What's your schedule, Mr. Green?
I'm pretty available at that point, Your Honor.
June 9th?
I'll be fine.
All right, I'll set, will be set as a sentencing hearing, June the 9th. And I'm going to need either treatment notes, either they deliver to you to bring to the court, or they furnish them directly to the court. And if they need, some agencies want some sort of authorization signed, you'll need to do that so that they can be revealed to the court. Okay, any questions?
No, sir. No, Your Honor.
All right, June the 9th, 10 o'clock.
Thank you.
For sentencing.
State of Ohio versus Michael G. Robbins, case number TRC 221566 A and B.
Okay, so on this one, I just texted the VA representative. I don't have anything back, so let's recall.
Okay. Thank you, Your Honor.
State of Ohio versus Thomas Wisdom, case number CRB 22810.
Mr. Wisecap is representing Mr. Wisdom.
Yes, Your Honor. Good morning.
Good morning. Set for pre-trial today.
I think I've spoken with Mr. Heald. I believe that he is going to take some more time to speak with the alleged victim in this case, and we'll just reset that if that's okay with the court. I think we've agreed on a date for May 20.
Is that the entry that you?
It is.
It's in there.
Is that back there? Do you want me to
Wait,
grab
maybe
it?
I'll run it out.
What was the date that you wanted to do?
I think it was maybe the last Friday in May.
That's the 26th.
26th, that was it. Oh, yeah.
All right, and there's an agreement that it would be continued to May 26th. Is that what time you stayed during it? Yes. All right, I'll execute your entry. So case will be set for another pretrial May 26th at 10 o'clock.
Thank you, Your Honor.
Your entry is approved.
All right, you're good to go.
State of Ohio versus Isaac Kelly, case number TRC 2311 A and B.
There was a possession. There was like a possession of marijuana charge. There was a This is
All right, Mr. Wisecap, this is your case also.
Yes, Your Honor. Spoken with Mr. Heald. I believe we have an agreement to resolve this case today.
All right, if you would state that for the record, please.
Yes, Your Honor. My understanding of the agreement is that in exchange for Mr. Kelly's plea of no contest to an OVI first, the state of Ohio would recommend the minimums on the OVI, and I believe would also agree to dismiss the remaining charges and cases that Mr. Kelly has.
Mr. Hill?
We are in agreement. I'm just looking at what I know there's a Mark Lanes violation.
Yeah, that's the only thing I see.
So we would nolly that upon a plea to the OVI.
Do you have the urine screening results back?
We do, Your Honor, and it showed an amount over 200 nanograms per milliliter of THC metabolite.
Okay. All right, Mr. Kelly, do you agree with what your attorney has represented to the court?
Yes, Your Honor.
You have the right to make a statement. Do you want to make any statement?
I won't be back here for the same thing again, I can promise that.
Okay,
I've learned my
that's
lesson.
good. I'll impose a $400 fine on the OVI, order you to pay the court costs, 20 days in jail, which I'll suspend on the condition that you do 5 days of community service, go to the driver intervention program and complete it, and serve 2 years of level 4 probation. Your license will be suspended 180 days, starting the day of the offense. Well, actually, it wouldn't be. It would start now, because there was not an automatic license suspension here, but it would start today.
Your Honor, Mr. Kelly would request driving privileges during the period of his suspension.
He can have driving privileges for employment, community service, to go to the 3-day program. Is there anything else that he needs privileges for?
No, just to go work out, that's all.
Well, no. You can go to work, but not for workout. You can run from your house. Get a bicycle. How far is the gym?
I can make it.
Okay. All right, I'll set your review hearing December the 8th. If you get everything finished before then, you don't have to show up. You can get 2 days of community service credit tomorrow if you come here at 7:30 a.m. Same thing the next Saturday. You get 2 days credit for one. So after that, I don't know if we'll have any more of those fire sales or not, but that's the only thing on the schedule right now. 2 for 1 this Saturday and next Saturday. 7:30 a.m. here at the court. You'll need to go speak with Mr. Major about his probation, and after that, he's free to go.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Austin C. Bates. Case number TRC 23209, A and B.
It's Mr. Smith's case. Austin Bates is set for pretrial today, and he did not.
Judge, I've had no contact. I don't know why he's not here. I would ask if there were more issues that be issued next Friday, and I'll try to find out why he's not here.
Be a warrant issued within 7 days, or 7 days if he hasn't appeared during that time frame.
State of Ohio versus Trina Blankenship. Case number CRP 23201, A and B.
Mr. Smith's case set for pretrial.
Judge, we'll need to get a trial date on this. There's been some negotiations today. My client's indicated she would like to exercise her right to a trial.
Okay. What's your May schedule like?
Just the 8th and 12th are bad. Any other day in May, I'm available.
Well, we've got 6 trials already set for the 8th, so that's...
Good.
You can't be here that day.
I can't be here that day anyway.
How about the 15th?
We'll be fine, Judge. Thank you.
I'll set this for May 15th at noon for trial.
State of Ohio versus Tracy J. McDonald, case number TRC 222574, A, B, C, D, and E.
Okay, it's a pretty good report.
Good.
This is a pretrial on the probation violation.
Yes, Judge.
So-
It's an old OVI case.
That was from November, so I think maybe we could wrap this up by, what I would be willing to do, I just wanted to get him back on track, which it looks like he is. So I'm okay with dismissing the probation violation as long as he's compliant with the original order, which was to finish treatment, which it looks like he's on course to do that now.
We have no objection, Your Honor.
I'm assuming the state has no objection. Okay, so did order that the probation violation is dismissed. Defendant is ordered to complete his original sentence. So I'm going to set it for a review hearing will be next. Continue on with your treatment sessions like you have been. And I'll set May 26th as his review hearing, first review hearing at 9 a.m. Okay, that's all.
Okay.
State of Ohio versus Gregory McNeely, case number CRV 23-3. Gregory McNeely.
Mr. Smith's case set for pretrial. Had been at Riverside. Is Riverside.
See what your report shows here.
Okay, it's a good report and good screens. Good job.
We're not sure yet of the graduation date. Perhaps if we come back one more time, maybe he's at that point or at least closer to it.
A month or how much?
A month is fine, Judge, the end of May.
May 26th.
I can do that. Thank you, Your Honor.
You're welcome.
May 26th at 10 o'clock.
State of Ohio versus Allison Snyder, case number CRV 23231.
Mr. Smith's case set as pretrial.
Your Honor, the worker from CPS could not be here today, but she did text me saying a report.
right, I have a report from Lawrence County CPS.
Yes.
And it's coming to my phone now, and I'm going to forward it to both of you. Well, when I get it, I'll forward it. It hasn't, it was on Mr. James' phone, he forwarded it to me, he doesn't have your addresses, and once it hits here, I'll forward it to you.
Okay.
I do have a report back on Michael Robbins, I think that was Mr. Cummings' case, we can do that.
Is it recall this one, Judge?
We'll recall Allison's sign. I'll send those reports, it's pretty lengthy, so I want you both to review it.
Thank you.
We can recall Michael Robbins. Mr. Cummings, come into court, please.
State of Ohio recall from Michael Robbins.
All right, on Michael Robbins, that case number is 22-1566. Mr. Cummings is representing. I did text Amanda Rayburn at the VA services, and she texted me back that he is in a long-term program with veterans and is participating and is compliant.
I also, Your Honor, had an update report showing that he went out from March 31st, and I had that put in the file.
Okay.
It didn't have any update as to now, but it was just showing the program and where he went.
Why don't we do May 26th then for a follow-up?
That'd be fine, Your Honor.
May 26th will be, and it'll be set as a sentencing for Michael Robbins. It's on 22-1566.
Thank you, Your Honor.
Thank you. Okay, I do have the Children's Services report now, and I'm forwarding that, Mr. Hill, to you and Mr. Smith. On Snyder.
State of Ohio versus Casey J. Jackson, case number CRV 22510 and CRV 22165 A and B.
This is Tyler Smith's case set for pretrial.
Did you get it? I haven't received anything. Okay, just you're supposed to send it. Your Honor, I don't know if the court's received a update from Path.
Not today, I have not.
Neither have I. They're supposed to send a letter to me as well.
I can ask them.
I can call her, I can step out and call her. Well, we'll get next, but.
Okay, we'll recall after we get a report. Last time we had to text them to get a report, so.
Yes. Go ahead and call.
out there. See if you need those.
State of Ohio versus Michelle Wade, case number CRB 23202 A and B.
It's, Attorney Tyler Smith's case for pretrial. Michelle Wade.
Just
If she wants a trial, might as well.
Your Honor, this is a co-defendant to a previous case.
One was set for trial?
Yes.
Same day?
May 15th is fine, Your Honor, yes.
All right, May 15 at noon for trial.
Thank you.
Thank you.
You're welcome.
State of Ohio recalls Allison Snyder, case number CRB 23231.
Mr. Smith's case.
Judge, I just got the first page of the report. I don't, did you get the whole?
Oh, yeah, all I got was the first page, too.
Okay. I think that's all I sent you.
Okay.
Okay, let's see, I need to see your friend. See that report back there. Okay, I'll send you the second page as soon as it hits.
Thank you, Judge.
State of Ohio versus Andrew R. Curry, case number CRB 22351. Mr. Steyer's case number, check here.
Mr. Steyer.
Your Honor, you may recall last week, Mr. Curry called the court, was unable to be here. I've attempted to return his call and tell him that the case was rescheduled today. I've not been successful in that, so I have no knowledge of his whereabouts.
Okay, he has 7 days before a warrant will issue to appear.
Thank you.
State of Ohio versus Mason DePriest, case number CRB 21189 and CRB 21221.
It's Mr. Steyer's case. Okay, it looks like there's still things to work on.
Yes, sir.
And are you willing to work on it?
Yeah.
Okay. And you're still willing to work with it?
Yes, sir.
Okay. Probably need to come back sooner than a month, though. How about the 19th?
I'm available that day, Your Honor.
All right, we'll see you on May the 19th, hopefully with a little better report, Mr. DePriest. Pre-trial, May the 19th, 10 o'clock.
Thank you.
Thank you, Your Honor.
Well,
State of Ohio versus Olivia J. O'Brien, case number CRB 23247, CRB 22570. Olivia O'Brien.
Mr. Stiers' case. Okay, I did get that second page and I'm forwarding it to you, Mr. Heald and Mr. Smith.
Your Honor, Ms. O'Brien advises me that I've been appointed to her on a new matter that is also set today, in addition to the older matter that I was already representing her on. I haven't looked at that yet, or discussed that with Mr. Heald. So if I could just a second speak to Mr. Heald.
It's the new case. It's a domestic.
So it sounds like the state needs to issue a subpoena for the complaining witness and would like to have some time to accomplish that. So we would not object to a continuance if the state made that motion.
Your Honor, we had received a message from the alleged victim, but when we returned the call, we weren't able to make connection with her. We want to make sure we have her input on this, on the new charge. And so we will ask to come back at a later date.
It's still better for you.
The other charge has been pending for some time, from clear back in September of last year. And Ms. O'Brien has been attending to treatment previously at OVP, it looks like. So I guess we maybe would want to see what's happening there.
And I have a report that I've received. I got it via email. I'm going to show it to Mr. Heald real quick, and then I can probably forward it by text.
And that's from OVP, Your Honor, and it appears that she is keeping up with the counseling requirements and still maybe has some things to work on.
And I've forwarded that document to your text, Your Honor.
All right, thank you. Yeah, this is good.
That matter when we've been tracking treatment on, I don't know that her treatment is necessarily expected to end, but I think so what we're looking for on this is more of a feeling where that she's gotten some time under her feet and some success in treatment. We anticipate that she'll be dealing with some various sorts of treatment on an ongoing basis, but not necessarily directly related to the incident.
May 19th, is that?
That day works, Your Honor.
Okay, next hearing on both cases will be May 19th for pre-trial.
Thank you.
10 o'clock.
State of Ohio versus Letitia N. Walker, case number CRB 22429 and CRB 22789. Letitia Walker. Did not check in, Your Honor.
Any ideas where the...
I don't have any information at this time, but Ms. Walker's been very good about getting in touch with me and staying in touch with me and appearing in court, so I would ask to continue this matter if I could. If I could set this for, I just have this set for the 8th.
Mr. Hill?
I'm going to attempt to contact her and get her in here.
Walker. This is a time waiver just on the 22 case. We don't oppose that, Your Honor.
Okay, finished request, case is continued to May the 8th for pretrial, 10 o'clock. Both 22-429 and 22-781, looks like. 789. That's a 9, not a 1. 789.
State of Ohio versus Sean DeWeese, case number PRV 22637, A and B.
When did that get here?
Mr. Morgan's case. Yeah. Set for pretrial today. I think we were looking for a report.
I don't believe that's going to tell the judge what to look at for.
Yeah. Probably got a little more than this, yes.
I would want to report what I would program and I was cleaning compliant. Yeah. Yeah, well, when somebody report on it, they give me the credit.
Well, this is not really a report, it just shows me that he's been there and that there's been billing for that.
I told her, sir, I told her you needed something to show, I've been showing up stuff, that's what they printed me out.
No, I need something showing what you're doing, and a report saying what your activities are and what's happening with your sessions. This is Pathway, so your Pathways in Ashland?
Yep, the one on the hill.
Okay, well, fortunately, I have a contact there, so.
Okay. The one's been seeing me is Morgan Harper.
Mr. West.
He's here, Your Honor.
All right, Mr. West, can you get us a report for, I'll send you his information.
Yeah.
This is Mr. DeWeese. So we'll recall.
Recall, thank you.
Okay, Mr. DeWeese's case will be recalled.
State of Ohio versus John McCoy, case number CRB 2697. Your Honor, he also has a case, besides his pretrial case that's for sentencing today, we have two different attorneys, Mr. Morford and Mr. Donald Smith.
Okay.
No, I don't. You must have the other John McCoy. There's two of us. Every time we come up here, it kind of mixed up. I think they got me as John J. It's actually John Henry, Jr. And then there's a John Daniel.
I think I'm John Daniel, and judge of the sentencing charge. So I'll sit back.
I just got 2 days.
Okay.
There is a John D. McCoy, and that's you, sir?
No, I'm John H.
Okay.
And
Let's see, this is case number CRB 697.
Actually,
Date of birth 11/23/88.
I'm just here because I have 2 days community service.
November 23rd.
Sorry? No, it's April 27th. Just had birthday yesterday.
What's your date of birth?
April 27th, 1968. All I have is 2 days community service, and I was going to apologize to the court.
Okay, well, that's actually, according to the file, Mr. Smith's case, 21/7/44.
That's the one I have.
Yeah, 4/27/68. He's got 2 days of community service left.
I want to apologize to the court for taking up the time. My mother-in-law passed away this month, and we were living with her, so it really...
McCoy was supposed to be here on 3/25.
We've been here twice. We've been here twice since.
I would suggest he work tomorrow. He can knock 2 days out, as I understand it, that 2 for 1.
I'm off with that, like I said.
Can you do that tomorrow?
Yeah, my mother-in-law passed away this last week. I started a new job the day after I was here.
But you can be here tomorrow?
Yeah, not a problem.
Okay, I'll reschedule this for May 19th, and if you finish it, you don't have to appear.
I'll be here tomorrow, so we ain't got to worry about it no more, and I apologize again.
Okay, then the other John McCoy is Mr. Morford's case. It's on the docket today also.
You don't have to worry about that.
John McCoy, 2697, Mr. Morford. That's the date of birth of November 23rd, 88. Is that John McCoy here?
Not sure.
Yeah, November 23rd, 88 is the date of birth. It's set for a pretrial today. And that John McCoy does not appear, so the evidence bench warrant issued.
Thank you, Judge.
You're welcome. Okay, we can do Allison Snyder if you're ready. Have you had a chance to review those reports, Mr. Smith? Mr. Smith?
I'm sorry. Yes.
State of Ohio recalls Allison Snyder, case number CRB 23231.
Well, the recommendation is for split custody. Of the 2 children.
Judges, as an M4, I discussed with Mr. Hill the possibility of a continuance and a dismissal. Assuming no further problems, my client's the one who initiated the call to the sheriff's department. I think the state's on board with that.
Okay.
you know, we are in agreement with that.
I guess an M4, I don't know how long the state wants to go out.
Month?
I prefer a month, something, so then CPS can continue to handle what's going on down there.
May 26th?
Yes, sir.
May 26th will be the next hearing, 10 o'clock.
Thank you, Judge.
State of Ohio versus Eddie Eastep, case number CRB 23203, TRC 21269, TRC 17442, A, B, and C. Eddie Eastep, did not check in, Your Honor.
Your Honor, if I may, I had a note that said to check on Mr. Eastep's community service from his previous cases. All of his community service on his old cases are complete.
Okay. Well, any explanation for he's got a new case.
I don't know where he is, Your Honor.
Okay. He's got 7 days to appear before a warrant will issue.
Thank you, Judge.
State of Ohio recalls Evan J. Holmes, case number TRC 22463, A and B.
All right, Mr. Holmes, you had a review hearing today, I guess, and somehow we missed getting you up here.
I was not here.
Okay, you were late getting here?
Yep.
And you're in a treatment facility now?
No.
Okay. Where did you come from?
I came from my house. I had a final exam this morning. I knew I was supposed to be here. That was the reason I was late.
Okay, you got, according to my records, about 2.5 days of community service left, and you got some fines to pay.
Yes, and I've finished that community service with the Warrens County Dog Shelter, and she said she sent my papers in, so.
I don't have it yet, but they're pretty good at sending it, Your Honor.
Okay. Do you have a payment on your fines?
Yes, of $100 today.
All right, see the clerk, no warrant for, I had said a warrant previously. I'll set your next hearing for June the 9th.
Got it. Thank you.
You finish everything, pay it off by then, you don't have to show up. June 9th, 9 a.m.
All right.
See the clerk to make your payment of $100.
Got you. Thank you.
You're welcome.
State of Ohio versus Cornell Rogers, case number CRB 23205, A and B. Cornell Rogers did not check in, Your Honor.
It's Mr. Morford's case, set for pretrial. He was supposed to be inpatient with Lawrence County Recovery. Are they here today, or we got in contact with them? He had April 7th, I released him on a $3,000 OR bond with inpatient services at Lawrence County Recovery. Do we have a person we can contact at Lawrence County Recovery? Let's recall that, because if he left there, if he's still there, I need to know if he left. They never notified the court that he left. I want to find out.
Judge, with respect to John McCoy, he's since contacted my office and said his vehicle's broken down and he cannot get a ride here.
Okay, so what do you want?
Well, issued a warrant for a week, so I'm gonna try to have him here Monday.
Okay, that'll work.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Gary Thompson, case number CRB 22526, A and B. Did not check in, Your Honor.
Gary Thompson is Mr. Morford's case. He has a bond up. He just had to pay the costs, which he didn't do, according to what I'm showing. He paid the court costs, the case was going to be dismissed today, but he hasn't paid it. Okay, well, we need to do a new entry saying the case had been, an ollie had been issued on March 24th, but he was supposed to pay costs, he hasn't paid the costs, so have the case reinstated with a warrant. Probably need to give her a warrant.
Is that Mr. Sauer's bond, Your Honor? That's what I've got.
Yes. So we'll need a bond forfeiture. Set for bond forfeiture May 19th.
Thank you, Your Honor.
State of Ohio versus Nicholas Holly, case number CRB 2397, CRA 23125, and CRB 23127.
All right, and Mr. Hawley, you still don't have an attorney?
No.
How's the state want to proceed with this?
So, Your Honor, Mr. Holly completed an online anger management course and then did an extra one. And the reason that they did the online course is because of his work schedule. And we had discussed that at a previous hearing, and we were okay with that, him proceeding that way. his mother's here. She's the alleged victim in this, and she says he's doing great. Apparently, he's got a better job even, still at Marathon.
No, he actually just started a new one. He's working at Engines Incorporated.
Okay, so he's working his way up in the world, and so I believe that we've reached a point at which we could move to dismiss the charges upon the payment of one court cost.
Okay, so that's all charges.
Yes, Your Honor.
Does that agree with you, Mr. Hawley? Yes, can you do that today?
What did you say?
Pay the court cost, one court cost,
Yes, sir.
$110.
Yeah.
Pay that today?
Yes, sir.
Okay, see the clerk, pay one court cost, and all your charges are dismissed. That's to the right as you leave the courtroom.
Thank you.
State of Ohio versus Keon Gage, case number CRA 23-238, CRA 22-537. Preliminary hearing, Your Honor.
Mr. Morphy's case.
In jail, Mr. James. He's in jail.
He's staying right.
Well, you forgot, I just have an eye on it. I step over here. I'm going to mute.
Is he going to waive? Has he got? Got a minute, we'll look here for a second. Your Honor, this is a matter in which Mr. Morford and I were able to speak about briefly prior to the hearing being called here in the courtroom. And I had suggested that there might be a way for us to keep these cases here, but it was going to involve the payment of some restitution and maybe some other sanctions. And we would still like to offer that to Mr. Gage, but I don't have the specifics in order to do that right now. So what I would like to do, if they would agree, instead of sending the case to the grand jury, I would like to be able to have another opportunity to look at it in detail and decide what we can propose as a resolution here in this court. So if they would like to continue it and waive time and come back in a week or two, we would like to do that.
That's agreeable with us, Your Honor.
Okay, I'm looking at dates of either May 8th or May 19th. What's best for you, Mr. Morford?
I think he would prefer the second due to
The 19th?
a medical appointment.
Okay.
And I'm here then, Judge.
All right, May 19 will be the next hearing. Defendant waives time constraints until then.
Yes, Your Honor.
State of Ohio versus Melissa Snell, case number CRA 23224, A and B.
This is Mr. Morford's case, preliminary hearing. good report. So it looks like we're on the right track and you're doing what you need to do.
Yep.
So we'll continue to monitor this situation. I would suggest a month out, May 26th. Continue to do what you're doing, Ms. Snell. You got a good start.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Antonio Caldwell, case number CRB 23243.
Butch.
Mr. Smith's case set for hearing in Antonio Caldwell.
Clients in the back, in the jail.
Just got to make sure I got to get address and contact numbers. Judge, there's going to be a waiver on this case, and I spoke with Mr. Hill, and for the waiver, he's going to recommend he stand his current bond with Mr. Sowers. They can't hear a burger case in this case. We're just waiting to get out. Oh, there's a waiver, Judge, I'm sorry, yes.
All right, you'll need to sign a waiver, and what you're doing, Mr. Caldwell, you're signing a document that says you waive the right for me to judge the state's evidence to make sure there's probable cause to send it to the grand jury. You're agreeing that it goes on to the grand jury. That will preserve your bond that you've already posted.
Okay.
So one of the things you need to do is make sure that Mr. Smith knows where you are. And
He's confirmed his address, Judge. He's going to give me his telephone number. He doesn't know it offhand, but he is at the same address.
unfortunately, I believe that only happens 50% of the time, doesn't it?
You would be correct, Your Honor.
The other thing you can do is monitor it yourself. Do you have access to a computer, sir?
Yeah.
Mr. Smith can include, there is a website for the clerk's office. You can keep checking to see if you've been indicted. If you have been, it would behoove yourself to go to the court in Ironton and turn yourself in so that you preserve your bond. If they appoint another lawyer other than Mr. Smith, he may not know how to get a hold of you or she, and then you get a warrant and you lose this bond that you've posted, even though you would have shown up if you'd known to show up. Doesn't make much sense, does it?
Yeah.
I can start saying this thing.
I'll make sure you know the next day it is for me. Good? You're good to go.
Oh, okay. Case is bound over to the grand jury. Waived to the grand jury.
I've got right to too.
State of Ohio versus Tamisha Shears, case number CRB 22578 and CRA 22634.
Mr. Smith's case, preliminary hearing. Okay, we needed a urine, we already have one. Okay, she's still positive for methadone. What's your level now?
It's still at 35.
Okay, well, you should be able to transition off now.
Yeah, it's, I'm just scared. This is the longest I've been clean. I've tried Suboxone about 2 years ago, and I kept relapsing on Suboxone, and I did some research about the shot and stuff, and I'm a little bit scared.
Well, I think what we'll have to do is send it on to the grand jury then, because you're not doing your treatment with, the plan was you're gonna stay here, go to treatment, do that with them, and get good reports, and eventually get the case dismissed. But you're not doing the treatment. You're not going to your sessions.
I do Zoom meetings Tuesday, Thursday, Saturday.
I think it needs to go to the grand jury. That's not acceptable.
Still have a possession, first degree misdemeanor possession charge. I don't know if that's from the same incident or not.
So you can take them both. You know, unless you're gonna make a commitment that you're gonna do the treatment that's set forth in this court, my only option is send you on down to the other court and then let you talk to them. Because you're not doing what you said you would do here. The deal here is if you don't want to get indicted on a felony, you agree to do the treatment that's set out for you here, and you're not doing it.
She is being recommended for residential services due to her not being compliant, but she would have to go to detox to get off the methadone. But she is being recommended for the residential.
Judge, she's indicated she just rather the case go to the grand jury.
Okay, you want to waive then to the grand jury?
We'll waive, Judge.
You've got an OR bond up.
I'm going to ask if she can stay on her bond, and we'll ask that continue.
Okay. Think you can sign a waiver?
Yes.
Well, the one's a misdemeanor, so it'll be, do they rise out of the same set of facts?
They're different dates.
So what do you want to do with the misdemeanor? Just keep it here, or?
The grand jury.
File it?
I mean, if we were going to keep it here, our goal would be for her to get treatment, which is what we
She's
want.
not doing that, so it's
Well,
not
I mean,
saying-
I understand, so I guess we just nolly it, and I don't think we can present it to the grand jury.
Okay, 22-578 is nollied outright.
Okay, then I'll,
And 22-634 is being waived to the grand jury.
Vote, Your Honor.
Yes. Okay, that's all. You need to stay in touch with Mr. Smith, and hopefully he can give you some information. Your case is presented to the grand jury. So what happens?
State of Ohio versus Court of Recalls Cornell Rogers, case number CRV 23205, A and B.
All right, this is Mr. Morford's case. Cornell Rogers left treatment, I'm told, the same day he went there.
That's correct, Your Honor.
So, knowledge of your injury? Oh, this is not a felony, it's a misdemeanor. Bench warrant. The bench warrant in this court.
Thank you, Judge.
You're welcome.
State State of Ohio recalls Allison Snyder, case number CRB 23231.
Oh, okay. Okay. So Children's Services is aware of the
Yes,
visitation.
yes.
Okay, this is, I thought we set it for May 26th.
We did, Judge, there's a protection order that's still in place, that the child's father's been texting my client saying that the boy wants to go back and see his mother. We're going to dismiss it the 26th, I assume. I would ask protection order to be lifted. She doesn't want to contact her son and
He's not
violate.
going to come back today,
No.
but he just wants the ability to be able to.
For
And
visitation.
he's scheduled for
Yes.
surgery, and he's on my insurance, so we kind of got a problem.
And this is where she was staying with mom, and he just now starts staying with dad, and she's got the insurance, the medical appointments.
Mr.
Well, Children's Services is involved,
Yes.
and I believe under the circumstances, most of what that letter, if I read it correctly, really was that there's behavioral issues with the young man, and that both parents, even though they are separated and estranged, still struggle with his well-being and whatnot, and that's how this arose. So I think under the circumstances, it would be, as long as Children's Services says that there can be visitation, then we shouldn't stand in the way of that. We would ask to dismiss the protection order.
Okay, visitation is allowed, protection order is dropped. May 26th will continue to be the next.
Yes, we will be here,
Yes, sir.
Judge, for that one.
Yes.
Thank you for recalling.
State of Ohio versus Stephen C. Cart, case number CRA 22667 A and B.
This is Tyler Smith's case, set for preliminary hearing. Yes.
Already did. Okay. When was that? Last Tuesday.
Very good report. And it's successfully completed.
Yes, Your Honor, he said he graduated last Tuesday.
So how's the state want to proceed?
Well, it appears that Mr. Cart has done everything asked of him and done it in a very successful way. We've had nothing but good reports since he started through the treatment program. So the certificate says he's graduated to independent living and outpatient maintenance services. So I don't know whether that is indicative of the need for more oversight by the court, or whether he's reached a level of completion that would allow us to dismiss the charges. I just don't know what.
What's your plan going forward, Mr. Hart?
I've purchased a trailer. It's moved in next to my daughter's aunt and across from her grandmother. I'm just a couple miles down the road from her. I'm not going back to Charleston, West Virginia, ever, where I came from.
Okay. So that's here in Lawrence County, or?
That's over in Canova, West Virginia.
West Virginia.
I'm retired from AT&T and Loomis Armored.
Well, it's up to you, Mr. Hill. Do you want to dismiss now, or do you want to see some follow up.
Well, I think, on the one hand, Mr. Cart appears to have done nothing except what was expected of him and what he expected of himself. I guess I'd like to know whether he intends to continue with services from Bethesda or whatever's being offered at this time, outpatient or whatever.
I wasn't planning on it. I don't see any need to.
Okay, well.
I don't like, I'll never go back to the way of life ever again. I can promise you that.
The thing about Mr. Cart is he is more mature than a lot of the people that we see through the court, and if he feels that he's reached that level of, he's secure that he's not going to go back to those bad habits, then we would be okay with going ahead to dismiss the charges.
Okay. Cases be dismissed due to your successful completion of treatment, sir. Congratulations.
Thank you, sir. I appreciate everything.
You're welcome.
Thank you.
Thank you, sir.
All right.
Good luck.
State of Ohio versus Buddy Lynch, case number CRA 2362.
Your Honor, this is set for a prelim today. The state's agreed to allow Mr. Lynch to plead to a reduced charge of misdemeanor theft. I've got proof that he has paid all restitution. There's the receipt.
There was a payment of $1271.42.
Yeah, that's full restitution, Your Honor. So we'll plead guilty to the misdemeanor.
So it'll be treated as a misdemeanor theft offense?
Yes, Your Honor.
Is this mine?
Did you need that back? Yeah, you don't need it. Thank you. So, it's just going to be probation. There might be some community service, I'll leave that up to him. But there will be a review date that's like at the end of the year or something, so it'll be far off.
All right, on Mr. Lynch, it'll just be the same statute number, but it'll be a M1. Change the level offense to an M1 from an F5. And you plead to that?
Yeah, we'll plead guilty to that,
that
in one
correct?
theft, yes.
Mr. Lynch, anything you want to tell me? No?
No.
Any recommended, was there a recommended sentence, or what was the position?
We would recommend, similar to how the court might treat a shoplifting charge from Walmart, some community service, a suspended jail sentence.
Yes, Your Honor.
Anything else you wish to?
Nothing further, Your Honor.
All right. This one's a little bit, I'm going to make the fine higher because it's a little different. I'm going to make it a $250 fine. Okay. Court costs, 10 days in jail suspended, 5 days of community service, so that's 30 hours of community service. You can get 2 days credit by coming out tomorrow, and then another 2 days credit next Saturday. We'll make it level 5 probation with a reviewing date of December the 8th. He's to see Mr. Major in the probation office to go over his terms of probation, then you're free to go.
Yeah.
Your Honor, the restitution was paid to the court, is that?
It's already been paid.
Yes. Yes,
So it's
sir.
paid to the court.
Wanted to make sure it was where it was paid to.
So on those days, you get double time on community service, so I talked to them about that. You get 2 for 1, so might as well knock it out. Okay? Great. All right, good. Back over to probation.
State of Ohio versus Teresa Heck, case numbers CRA 23199 and TRC 23323. Case number CRV 20831.
Okay, it's a good report.
Yes, sir.
So continue to monitor and
Yes, Your Honor. So my understanding when I arrived this morning, Mr. Hill told me that there was actually an old outstanding case from 2020. I have not been retained on that, but I'll include that in my representation. I haven't had a chance to talk to Ms. Heck about it yet. We would continue any prelim right now to allow her to complete services and to get any urine screens back that are pending from the state.
Your Honor, if I may.
yes.
Due to her diagnosis at our program, she is not required to take urine screens. She's only been diagnosed with severe anxiety and mild marijuana use. So Medicaid will not pay for drug screens because there's no medical necessity there.
Your Honor, I was referring to the drug screen completed by the state.
One request I made of Mr. Haslam was to find out whether Ms. Heck has a prescription for hydrocodone.
And I will do that. I haven't had an opportunity to speak with her about that yet, Your Honor.
So there is the issue of, there's a felony drug charge pending. If it were something that would be illicit regardless, such as some of these other things like meth or heroin, we would be looking at sending it to the grand jury. This is a prescription medication that is potentially, that she has a prescription. I don't know whether she does or not, but for that reason, we are willing to look at continuing to leave the case here while we find out what's in the urine, find out if there's a prescription, but we would need a time waiver to do that.
And Your Honor, we'd be willing to enter a time waiver to do that.
Okay.
I would like to speak to the other charge too, Your Honor.
Excuse me. Go ahead.
Bless you. The domestic violence charge is 3 years old, so we're going to have to try to make contact with the alleged victim, and we'll try to dispose of that in some way shortly.
Okay. Do we need a month or less time for that to come back?
Your Honor, I'm fine to give it a month to come back on. I've got trial the next couple of weeks.
May 26th then?
Let me double check, Your Honor, but I believe that will work. That works for my calendar, Your Honor, so May 26th is perfect.
May 26th will be the next hearing, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus Daniel Craig Collier. Case number TRC 23448, A, B, and C.
Sir, are you Daniel Collier?
Yes, sir.
All right, Mr. Collier, were you present in court when I explained rights, or do you want me to go over that with you?
I didn't know nothing about it today.
Oh, okay. All right, so you weren't here. So let me go over your rights with you. You have the right to remain silent. You don't have to say anything. But if you do say things, what you say is on the record, so it can be used against you if you admit something that could help the state. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
You've been charged with operating a vehicle while being intoxicated. The state's alleging that on April 22nd at 6:40 p.m. in Perry Township, you were operating a vehicle while being under the influence of alcohol And it's alleged that you took a breath test and tested 26 on the breath test. So that's over what's called the per se level under Ohio law. The per se level is 8. And what that means is if you take a breath test, test 8 or higher on the breath test, and if the state can show compliance with the rules for giving that test, then it's presumed that you're impaired because you tested 8 or higher. Well, the state's alleged you tested 26, so it's a lot more than 8. So that would be over the per se level. Now, it's also over the 1.7, which is the high test level, I guess I should say. If you have a test score above 17, a breath test above 17 under Ohio law is considered a high test score. That increases the minimum mandatory penalty. So they're saying you tested 26. So on our first, well, it's alleged that you've got some priors, but I think they're all past the look-back period. So this would be considered a first offense within the look-back period. But on a first offense, the maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty with a test score of 26 is 3 days in jail and 3 days in a treatment program. I have to give you both. The 3 days in jail is added because of the high test score. If you had a test score below 17 and were found guilty, I don't have to give you 3 days jail. I can give you 3 days jail, but I don't have to. If you test above 17 and are found guilty, the legislature says I have to give you at least 3 days in jail. The minimum fine is $375 fine, and a 6-month license suspension is the minimum license suspension. Do you understand those things I just explained?
Yes, sir.
Then the state's also alleging that you were driving while your license was suspended. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine, and that you were driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these 3 charges?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to these charges?
Can I say something first, or?
No, you need to tell me what your plea is, and then we'll decide how we're going to proceed. You can plead guilty, not guilty, or no contest. And if you're not sure what to do, you should enter a not guilty plea.
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
Yeah.
Do you have a job?
No.
Do you have any income at all?
No. And
Yeah, OVP brought you today. You were at OVP.
yeah, I actually, what, can I say what happened? So I was on.
Well, I don't want you to tell me what happened. Let's get you, because you asked for a lawyer. Is Mr. Steyer here?
Yes, Your Honor.
Okay. I'll appoint you, Mr. Steyer. Not guilty plea is entered.
I believe I heard this is a breath test case.
Yes.
I'm available the 8th. Would that work?
It could. I'm concerned, and we need Mr. Gill back to talk about bond. It's my understanding he was released from, or taken to the jail to OVP due to detoxing from alcohol.
Yes.
So, are you willing to go back there, or what's your?
Yeah.
You want to go back to OVP?
Yes. I've been there, it'll be a week tomorrow.
Okay.
Did they bring you here today?
Yeah. And the state patrol took me to
OVP?
OVP.
Is there somebody from OVP here now, or they just?
No, they called, I don't know, I gotta.
They just kicked you out as they drove by and went back, or what?
Well, yeah.
They gave you a number to call?
They gave me a number to call for him to come pick me back.
Yeah, he's got a number written down here and it says Claude, which I assume is the individual, the case manager or whatever is gonna pick him up.
Did they even slow down when they brought you here or what?
I got a little road rash.
Okay. Well, I think he needs to go back to OVP. And if he agrees to do that, I'll give him a signature bond.
Well, it sounds like he's agreeable, Your Honor.
Okay.
Yes, sir.
So, $2,000 OR bond with condition that he stay OVP.
Yeah.
I'll walk around that way. Sign your name right here, please.
That's it.
I'm sorry.
Just sign my name right there?
Right here, yeah.
And would you say May 8th?
Yeah, I asked for May 8th, Your Honor.
This should be. Okay. It's getting to be not okay, but it's okay.
Well, we do have those, that is the day that the
6 trials.
Porter matter
Is that
is set
6
as
trials?
well.
Mike, I take that day off.
I'm on one of those trials, Your Honor. Actually, 2 of them.
Actually, I think that, okay, so it's 2 different people. We've already done one of the trials.
There's other trials related to other charges.
There are? Okay.
I believe so.
Well, we'll just take them as they come.
I don't know, I could be wrong on that. 15th, I'm available. 12th, 19th.
It's worse than the 8th.
12th and 19th.
They're all about, well, actually, the 8th and the 19th are the 2 best dates right now. As the 5th, I'm kind of trying to preserve it.
Well, I'm available the 8th if it's one of the 2.
Do May 8th.
All right, thank you.
May 8th at 10 o'clock. How are you feeling, Mr. Collier?
Nervous?
A little shaky?
Yeah.
Okay. Are they taking good care of you at OVP?
Yeah, it's a great place.
Good.
Yeah, feed you good, and we got groups all day. Right, when they called me out, we was having church service.
Okay. Well, we'll get you back there. We'll see you on May the 8th.
Thank you, Your Honor.
May the 8th.
Just wait for me. I'll be up in a minute.
State of Ohio recalls Nathan Boyd.
All right. Have you seen the results?
Yeah, I think John already brought him back in.
See it? So I don't think that's exactly what we wanted to see, is it?
No.
So what's going, I mean, the report I have says he hasn't been attending services, but he's been in since this was written, or?
Yeah, he came in this past Wednesday for group.
I'd been out of town. I work out of town a lot.
Well, looks like we still got stuff to work on.
Yes, sir. I don't have to leave again until the 7th, so all next week I can get some more community service done. I was here, or I went and done community service Wednesday, but
You can get 2 days tomorrow.
yeah, I'll be here. And next Saturday too,
Then
right?
when you're leaving the 7th,
Yes, sir.
and then how long will you be gone?
It's, I think a couple weeks. It's kind of hit and miss. we don't really know how long it's gonna take until we get there and see what's going on.
So if I set it to 26, you most likely would be back, because that's almost 3 weeks
26th,
of May.
possibly.
Okay, I'm going to set it for May 26th. If you're not able to make, if you're out of town, do you have a smartphone?
Yeah.
You can appear by teleconference.
Okay.
But I want you, in the meantime, I want a better report, and get in there and do what you're supposed to be doing.
Yes, sir.
Okay, May 26th is your next hearing date.
Thank you.
You're welcome.
State of Ohio recalls Casey Jackson, case number CRB 22510, CRB 22165, A and B.
Can you check to see if, because they usually fax it, I do not have a report from Pat.
And the services he's receiving, Your Honor, from Pat are in anger management and parenting. I don't know why we have issues with them sending reports.
Well, the last report wasn't very good.
We do not have it yet, Your Honor. The last time I believe it was they didn't fax it the next day.
Yeah, evidently the counselor was out and couldn't prepare a report and was going to send one out later, but Mr. Jackson actually called after it was called up the first time and told them to send it, and they said they were working on it, but I don't know how long it takes to do it.
What does he say he's done since the last time he was here? I mean, has he been going to the sessions? Because this one says March 31st. Mr. Jackson has attended one session since March 7th. He's given minimal participation during his sessions. He was reminded that his participation was a recommendation from the court. He has moved from his residence and not updated this office to how to contact him to schedule an appointment. That was March 31st.
Well, she said the fax was on its way, so I don't know why.
Okay, but that's the last report. What are you doing now?
I'm still going every 2 weeks.
Every 2 weeks, is it
2 weeks.
in person or do you?
Both, over the phone and in person.
Over the phone and in person, okay. Have you updated your contact information?
Yeah.
Well, I still need a report. I mean, that was the agreement that he was going to go there and get some counseling. I don't feel like I have proof that he's done that, Mr. Hill.
I see that on April the 3rd, my notes indicate that there was a report, but that it wasn't a good report.
That's
And-
that March 31st report.
Okay, and then on previous dates, they had failed to give a report, so I don't know what the deal is there, but we need to have a report. We'd like to see a report that says that he's taking this seriously and he's making progress towards completion.
That's what was on this report that they're supposed to send.
So I don't know whether they can be asked to send us a report today or not.
They were asked.
I did. I contacted my contact with Pat, and he said he messaged the therapist. I said, tell him we need it as soon as possible, and that was at 11:17. So.
Yeah, she stopped texting me back too. She won't respond to nothing.
The therapist?
Yeah.
That's who you contacted this morning?
Brandon.
Randy?
Maybe if we just came back in a short period of time and hopefully we'll have something from them by then.
We can come back Monday, Your Honor, if that's...
Let's do May 5th. Are you available then?
Yes, Your Honor. Next Friday.
Okay, 1 week.
All right. Thank you, Your Honor.
You're welcome.
State of Ohio recalls Sean DeWeese, case number CRB 22637, A and B.
Okay, and we're going to get a report on Mr. DeWeese.
Okay, Mr. DeWeese, he's seeing a Morgan from, she's down in Morgan County. Her name's Morgan Harper, and she does telehealth anger management. She only does it on certain days. They've had some conflict with the scheduling on him being able to make it. And, but the times that he was there, he's been engaged. And now he's moved over to South Point. So I've informed him on how to cancel his Kentucky insurance and pick up Ohio. And I've been making calls out here trying to see who can see him for anger management. Mended Reeds is about the closest that I got, and they said they would do an intake on him, and him and the counselor could just focus on his anger management. But that's the closest I've got to somebody seeing him for anger management over here.
All right, Mr. Hill.
We'd like to see that transition completed. And then hopefully if Mended Reeds takes over, they will have records or whatever from the previous counselor to know what progress has already been made, so he doesn't have to maybe start all the way over again if he's made progress.
Okay, come back May 26th.
Yes, Your Honor.
And he's transitioning to Mended Reeds. And you've got the contact information and how to get a hold of him?
Yeah, I'll get him a way out. Like,
Okay.
thank you, Judge.
Hey, Butch.
State of Ohio recalls Daniel Collier, case number TRC 23448, A, B, and C.
Your Honor, I'm not certain whether this is something that actually would require a court order or not, but his car was impounded on the night of the alleged incident, or evening of the alleged incident, and he'd like to be able to get that out of impound. Now, he won't be able to do that. He's alleged to have a driver's license suspension. Obviously, there's an ALS in effect as well, but I don't see why he couldn't have somebody else pick it up. This is charged as a first offense. High test first offense, but there's nothing in that statute that requires the impound of the vehicle. It's been impounded for about, looks like 6 days at this point, so we'd like to try to let him get that out before the fee gets any higher. But just in case there's need for an order, I wanted to have it recalled rather than just have to go try to move it.
What's the state's position on it?
If there's nothing that is required as far as an impoundment, we don't have a problem with the vehicle being released.
I don't see that they filed paperwork for an impoundment. So if you want to prepare an entry that Mr. Hill agrees to, directing he was towed to a particular...
I don't have that information.
It's in the file.
Oh, is it in there?
I believe, yeah.
I didn't see that.
By Dalton's Towing.
Dalton's?
Ironton.
Okay.
Or prepare an entry, I'll sign.
I'll prepare that, thank you.
So we'll keep the May 8th date.
Get that straightened out.
Yes.
State of Ohio versus Christopher Haberlin. Case number TRC 191630, A, B, and C. Christopher Haberlin.
Mr. Morford's case is set for sentencing. Christopher Haberlin.
Are you Haberlin?
Christopher Haberlin. Haberlin.
Judge, I don't think he's going to be here. I got a Facebook messenger this morning. Hey, buddy, I'm in a real mess this morning and just called for a tow truck. Can you get this postponed till Monday or anything? He also called here and left the same message with Vivian, Your Honor.
Okay. Well, he's got 7 days to get in, so if he comes in Monday, we'll deal with it then.
Thank you, Judge.
You're welcome.
State of Ohio versus Clyde King. Case number TRD 20-2187 and TRB 20-825.
Mr. Steyer's case, sentencing.
It's not his property, it's not Maryland property. Okay.
I'm sorry? Okay. Mr. King's indicating he paid on his fines this morning.
Online?
Yes, sir.
Okay, so that won't be credited until at least Monday, I
You need to
think.
get out here tomorrow to get your,
Oh,
you still
yeah.
got community service, you get
Yeah,
double credit tomorrow.
yeah, I heard you
And
say
next
that.
Saturday.
Okay, I'll be here both days.
Does he need to report here for that, or is there a special place for him to go? Okay.
Here at 7:30.
Just wanted to make sure. Thank you.
May 26th for sentencing, next hearing.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Leah DeChambeau. Case number CRB 23-160.
May I approach, Your Honor?
Yes. All right, Ms. DeChambeau is here, and the issue on this is restitution. So, does the state have any evidence on that?
Well, she pled to the charge, and we delayed sentencing to today in order for the restitution to be paid, $106.76 and $260.
$372.76 was paid on March 31st.
So that's what we asked for.
Is that the restitution amount?
Yes. So, other than that, we would just ask for a small fine.
Anything you wish to say, ma'am?
No.
Okay. Was this for the medical bill, or what was it for?
$260 was for the medical bill, and then $106.76 was for the vet bill.
Okay. All right, I'll impose a $25 fine and court costs.
Okay.
Do you need time to pay that?
What's the, I can do the 20, I don't know how much court costs.
110,
I
135.
think I can do that. I'd have to go grab my wallet from my car.
Okay, well, if you get it by 4, I won't impose any probation or anything like that, so.
Okay.
Just pay it off before 4 o'clock today.
Okay. Thank you, sir.
See the clerk.
Okay, thank you.
You're welcome.
State of Ohio versus Clifton Mills, case number PRV 2311.
All right, Mr. Mills is here. It's on a sentencing. And my notes were to finish it up, his part of it today. I think Amber's been out of pocket for a while.
I haven't talked to her. I don't even know what she's got going on.
Well, she's got a warrant, I think, from this court for not appearing.
I don't doubt it.
What's the state's position on it?
We were indicating that we would want the case to be finished up this time. We were waiting on an indication from the VA, and I guess that's what came today, right?
Yes. Got a good report.
So we would go ahead and move to dismiss the charge upon the payment of court costs.
Is that agreeable with you, Mr. Mills?
What did he say?
He said he would dismiss it if you paid the court costs.
Sure.
$110.
110?
Yes.
All right.
Can you do that today?
I can do it as soon as I walk out the door.
Go see the clerk, pay your costs, and your case is dismissed.
Nothing on my record.
Nothing on your record.
Thank you, Judge.
You're welcome.
Question.
Let's go ahead and do that.
State of Ohio versus Tina Wells, case number PRV 13688 A and B, and CRV 141276. It's on the recall.
Okay. All right, Ms. Wells. How'd you like being locked up in the holding cell?
I didn't.
Well, that is the Greenbrier compared to our county jail. Have you ever been to the Greenbrier? It's pretty nice. It's right past it. Whatever hotel you want to think is really nice, that is that compared to our jail. I don't want to put you in jail, but you're not doing anything. You got to get this taken care of, okay? You got some community service to do. Tomorrow, if you show up, you get 2 days credit. You show up here, they'll drive you up to the fairgrounds. You'll mill around all day. They're going to feed you. They'll probably have hot dogs. I don't know. It's not going to be that hard of a thing. But you get credit for 2 days. You got to jump through these hoops. I mean,
I made a payment last time and I had a payment with me today.
I know, but you got community service. This is from a case in 2014. You've never done 1 day of community service from 2014 till now.
I'm still having trouble with my hip, Your Honor.
Well, all you got, we'll accommodate that. The thing is, I mean, let me look and see. I'm going to say you probably got suspended jail time. You got 9 days of suspended jail time. That's the option, because you can go down, maybe they've got probably because of your condition with your hip, they may make a accommodation, actually put you in a cot, because some people are on the floor on mats a lot of times at the jail. So community service is instead of going to jail. Wouldn't you rather do that than go to the jailhouse? I would. I mean, even if my hip hurt, I would rather go to the fairgrounds and mill around all day and eat a hot dog and maybe help somebody do something up there at the fairgrounds rather than go to the jail. Come on. Get this done, or I'm going to just have to send you down there. And believe me, you don't want to go, the sheriff doesn't want you there, I don't want you to go, but you're like testing my patience. You just won't do this stuff. So, at least tell me you're gonna do it.
I'm gonna do it.
You be here tomorrow morning, 7:30. Okay, your next hearing is gonna be May 26th. Your next review hearing, May 26th, she can be released.
State of Ohio versus Christopher Call, case number CRA 23-246, A, B, and C, CRB 23-249.
Okay, this is set for preliminary hearing today. Mr. Morford is the attorney, and he's here. So, are we going to have an actual hearing then, Mr. Morford?
No, Your Honor, I've been asked by my client to address the matter of bond.
Okay.
I believe the state is willing to agree to amend the bond to about $82,000 and change.
How much?
$82,000 and change real estate bond. I can give you the exact figure, Judge.
We're considering that at this point. I believe that the alleged victim is here, and I believe that Jasmine is speaking with her at this time.
Okay.
It's been presented. That would be a pretty substantial property bond, and if we did agree to that, we would also ask for GPS house arrest, and of course a protection order if we haven't already had one issued. So if we decide to do that, if we could just have a little bit of time to make sure that we can do that.
Okay, we'll recall that. You can go back and hold the prosecutor's talking to the complaining parties about some of these issues.
Judge, I believe
It would be a different process.
Okay.
State of Ohio versus Tessa Hickman, case number CRE 23-250, A and B, CRB 23-251.
This is set for preliminary hearing and pretrial today.
Judge, she was assessed by Bethesda, and she has West Virginia Medicaid. If you can have
She's in the
plans towards.
They told me they dropped.
See, that's why I was looking at you, Ron, like, okay. And
Well, we'll need to get her on the teleconference then.
Anyway, she was assessed and she's agreeable to go to inpatient, as I understand it. She has a West Virginia Medicaid card.
Well, we'll get her up when we get to the jail, and we'll do her, this jail folks. Okay.
State of Ohio versus Chadwick Coyle at the Lawrence County Jail, case number CRA 23-255.
This is for arraignment. Says the jail know we're ready.
They were giving a message, I'll call them now.
Okay, if somebody in the clerk's office is listening, I'm told that I've got a report on the fax machine from Pat.
State of Ohio versus Jeffrey H. Ralph, case number CRB 21900, CRB 21602.
She's okay.
All right, this was set today for review hearing. And you were late getting here, you just have fines and costs today. Do you have a payment?
Only 15 right now.
We'll take 15. Make your payment, and I'll set May 26th as your next hearing.
All right.
May 26th, 9 o'clock. See the clerk, I'll cancel the warrant.
All right. Thank you.
You're welcome.
We do have a report, she's running. I read it.
Okay. Who is the attorney on that?
Tyler Smith.
I'll just send him a copy. And you, Mr. Hill, I did get a report on Casey Jackson. All right, so we're at the jails now.
Recording has started.
Do you have the file?
All right, sir, are you Chadwick Coyle?
Yes, Your Honor, I am.
Mr. Coyle, I'm Judge Capper at the Lawrence County Municipal Court, which is where your hearing's taking place in Chesapeake. You're appearing by teleconference. Your image is in the courtroom today.
Thank you.
So what you say is all being recorded, and your image is being recorded too. And this is what's called an arraignment hearing. And the reason we're here, it's alleged there's a warrant for a Chadwick L. Coyle in the Court of Common Pleas of Ross County. Judge Matthew Schmidt. It's alleged that there is a warrant issued for your failure to appear for a hearing there. And this is what's called a Rule 4 hearing. It's a hearing, if you're arrested on a warrant from a county that doesn't touch the county that you are in, then you have a hearing, have a right to a hearing just to make sure it's the right person, that we don't nab somebody and send them someplace they don't belong. going. So the hearing will be whether you did or didn't do what they allege. It's going to be, are you the right person? And you have a right to have an attorney at that hearing to represent you. You have a right to remain silent. You don't have to say anything. You can have an attorney appointed if you can't afford one, and you have a right to bail. You understand all those things?
Yes, sir. I also have a question, Your Honor. There's $1,000 bail on this case. My father's actually at the courthouse, but they're saying that I have to be brought back there to sign the bond. My wife is also in the courtroom with me there. She knows more about it than what I do. But is there, I mean, I was just diagnosed Monday with a severe lung disease. Asbestosis, I have COPD, and asthma. They put me on 3 liters of oxygen. Therefore, I'm not receiving any of that, but at the same time, I've got many of the hospitals that the doctor's appointment at 1:45 a day. My phone is not.
Okay, well, this proceeding trumps your medical proceedings, so that's going to fall by the wayside, unfortunately. So, sir, just be quiet for a minute. Let me explain to you the procedure. You just answer my questions.
Yes, sir.
Do you want to have a hearing here in this court to decide if you are the person being sought by Ross County?
I am the person that they're on.
Okay. So you don't want an attorney appointed here to represent you on that issue?
No, sir.
They're only asking for $1,000 cash bond, so that's what I would set. So you can hire a bail bondsman and post bond here, and then if you go turn yourself in Ross County, I'll release the bond. Now, if you don't show up there and you don't explain adequately your non-appearance, then I'm going to tell the bail bondsman they have to go fetch you and bring you back to the jail. Do you want to post a bond? I mean, that seems...
I have the $1,000 cash right now.
Okay.
My wife and my father have it.
All right, it has to be posted here, since you're in custody here.
Okay, so then once I'm released from there, my wife is there in the courtroom, Your Honor. I'm not...
Well, that doesn't matter, sir. I don't care if your wife's here or not. It doesn't matter. You just answer my questions and let's stay on point and not deviate off. Do you want to post bond?
Yes.
Okay, I'm going to set your bond at $1,500 cash or surety. So if you got $1,500 cash, you can post it here. As long as you show up when I tell you to in Ross County, you'll get the whole $1,500 back. Or you can use a bail bondsman and you pay them a fee. It's usually 10%. So $150 gets you out here.
I have the entire amount, sir.
Okay. So I'm going to set it at $1,500. I'm going to give you a week to turn yourself in Ross County.
Thank you, Your Honor.
So bond will be $1,500, cash or
Thank you
surety.
so much, Your Honor.
Then you've got until, so that's going to be May the 5th.
Yes, sir.
I want you to turn yourself in Ross County before May the 5th at 8 a.m.
Okay, is that at the Ross County Jail then?
I don't care where, as long as they withdraw the warrant, whatever you got to do. If you got to show up at the judge's courtroom or the jail, I think either one would probably work. But you guys show up there, and we're going to need to have, I don't have a waiver. Yeah, I do have a waiver, sorry. Okay, so we're going to send something down.
Okay, sir.
For you to sign waiving the hearing here.
Okay. I wasn't even aware of this court date in the first place for Ross County, but that's nor here or there. It's
Correct.
all good. I just want to get it taken care of. I was on my way home from work yesterday, and now I'm here.
Okay, so you're going to post the bond today before 4 o'clock, correct?
Yes. It'll be posted right away, sir. And then that'll release me from this county jail, correct?
Correct.
To go home. Thank you, Your Honor. So does that mean at this time that I don't have to sign any kind of like waiver of extradition? I don't even know what that is, but.
Yeah, you do have to sign it, but that's what I'm filling out right now.
Okay, sir, thank you.
That's what I'm writing up, so I'll read it to you after I finish it.
Oh, thank you. I guess I'm just asking too many questions.
No, you're not. But you're interjecting at times you don't need to.
Thank you. Sorry.
He said he had something to say on his phone. Jeffrey Charles said. Okay. So, Mr. Coyle.
Yes, sir.
I'm ordering that you post bond today before 4 p.m.
Okay, sir.
And that's $1,500 cash or surety, so you can use a bail bondsman or you can post the $1,500 yourself, and you get it all back as long as you appear as you say you will. Then you're ordered
Yes,
to
sir.
appear in Ross County and have your warrant withdrawn before May the 5th at 8 a.m. So early that morning, because we have court on May the 5th, when we come in here Monday morning, or next Friday morning, that warrant's got to be off the books. You got to have had it withdrawn by appearing in Ross County. And if you don't,
I will be there.
if you don't, then you need to come back here and appear in this court May the 5th at 10 a.m. and explain why you did not go to Ross County. And if you don't do either of those things, then either your bond will be forfeited if you posted the whole $1,500, or
Yes.
if you used a bail bondsman, I will release him and order him to go fetch you and take you to the jail for not appearing.
Thank you.
Do you understand what you need to do?
Yes, sir, Your Honor.
Okay.
I will be there. I will be there on May 5th.
So that gives you all next week to get up to Ross County and do whatever they want you to do to get that warrant withdrawn.
Right.
So I'm going to send this down. It's a waiver of a Rule 4 hearing, and you'll need to sign it. I'll put an X on here where you need to sign, and it just says you're agreeing that you are the person being sought in Ross County, and you're agreeing to go there.
Okay.
Okay?
Thank you. Thank you very much, Your
Do
Honor.
you have any questions?
No, not at this time, just as long as I'm able to post that bond and be released, sir.
Well, the court will be open till 4. If somebody comes with the money before 4, they'll take it, and they'll send a release to the jail, or you can get in touch with the bail bondsman, make arrangements with him, and he lets the court know, then we'll send a release to the jail.
Thank you very much, Your Honor.
Okay, I think your wife is making arrangements with the bail bondsman as we speak.
Okay, I figured.
Okay, that's all.
Thank you, sir.
You're welcome.
State of Ohio versus Rebecca Cooper, case number CRA 23257, and Tessa Hickman is on deck.
So that needs to go to the jail, that Rule 4 waiver.
Does he still sign a waiver?
Yeah, he's waiving the hearing. Okay, ma'am, are you Rebecca Cooper?
Yes,
Okay, this is another Rule 4 hearing, just like the last one. This is, I'm Judge Capper, and this is a hearing on a warrant that was issued out of Pike County, which is Waverly, a warrant that alleges that you failed to appear there on some charges, and it looks like the charge, some sort of probation violation. Probation violation / contempt is what it says on the warrant. So you have a right, I'm sorry?
I'm sorry. I was just wondering what the original charge was.
I do not know that. Oh, no, I do. I just didn't look in the right place. Possession of drugs.
because when I got pulled over on my way to work yesterday, they said it was an assault and a vandalism.
I don't see that. The warrant says 29, 25, 11, possession of drugs, and then below that it says failure to appear, probation violation, contempt. So, you have a right to have a hearing in this court, and let me explain your rights. You have a right to remain silent. You don't have to say anything. What you do say is on the record, so if you admit something about this case that can be used against you, you have a right to have an attorney, to have one appointed if you can't afford one, and you have a right to have bond. Do you understand all that? So the issue in this court is not whether you did or didn't violate your probation or whether you were on probation, because that will be up to the Pike County Court. The issue in this court is going to be, are you the Rebecca Y. Cooper that Pike County wants, and is there good reason to send you to that jurisdiction to appear on this warrant? That's the whole issue before this court, whether I should send you to Pike County. Do you want to have a hearing about that, or do you want to agree that you are the Rebecca Cooper and that you will agree to go to Pike County?
I mean, I'm sure, I was been here, so yes.
Yeah, 2020 it looks like is when this was. Okay, so you do not want to have what is called a Rule 4 hearing. You're going to waive the right to have that hearing to make the state prove you're the person they're seeking to go to Pike County. Okay, so now, the good news for you is they're only asking for a $1,500 bond. So is that a bond you think you could post? If you can post bond, I'll let you out of jail here, order you to go turn yourself in Pike County. And if you do so, then I'll release the bond here. Do you think you could post a $1,500 bond?
Would that be 150?
Probably. Well, it's up to the bail bondsman. I can't make him post the bond. He may talk to you and say, well, she's high risk. I don't want to post her bond. Or he may want to. That's something you have to talk to the bail bondsman. If you got $1,500 in cash, you can post that with the clerk, and you get it all back as long as you show up in Waverly.
I don't have that much in cash. I just got a new job. I'm a server at Extradition house. I do really good now. I have a year clean. I do outpatient at LCR. I've been there for a while. And I have a place. But no, I do not have that.
But you think you could post the surety bond?
Absolutely.
So you want to talk to a bail bondsman?
Yes, no.
Okay. We'll let Mr. Sowards know that you want to talk to him. I'm going to set your bond at $1,500, just what they requested, and I'll give you what I'm going to do, because you're not sure you can post it, or are you sure you can post it?
Yes, I'm absolutely sure.
Okay. Well, what I'm going to do is I'll check the jail list to see if you're still there Monday, because that means you didn't post bond. But I'm going to assume that you will post it. And that's May 1st, isn't it? Okay, I'm going to put you back on my docket on May the 5th, but I'm going to check May 1st to see if you're still sitting in the jail. If you are, then maybe we'll make different arrangements, because what happens is, if you can't post bond, then I'll order Pike County to come and get you. And I'll give them a certain time frame in which to do that. But I'm not going to tell them to come get you if you're going to post bond.
Right.
So let's wait and see if you can post bond. I'm going to order you, I'll give you next week to turn yourself in. So you got to do it before Friday morning. You got to turn yourself in Pike County. If you can't, then you got to come to, you know where the court is in Chesapeake?
Yes.
You got to show up here Friday morning and say, Judge, sorry, but I didn't get to Pike County, and here's why. And give me a reason why you weren't able to get up there. Otherwise, I'm going to order the bail bondsman to go pick you up and take you to the jailhouse for not complying. Okay. Okay, so here's what I'm going to order. I'm going to order you to postpone and then go appear in Pike County before May the 5th, that's next Friday at 8 a.m. So you got to get there before next Friday morning. And if you can't do that, then you got to come back to the court here Friday morning at 10 a.m. and we're going to have a hearing and let you explain why you could not get to Pike County. And if you don't do either, if you get out and you don't show up in Pike County and you don't show up here, then I'm going to order the bail bondsman to come pick you up. Okay, so I'm signing that order. I'm going to send it down and you need to sign it. And by signing this, you're waiving your right to have a hearing to decide if you are the person being sought by Pike County and agreeing to these terms of the bond. Do you have any questions, Ms. Cooper?
No, Your Honor.
Okay, that should be coming down here in the next hour or so for your signature.
Thank you so much.
You're welcome. Good luck. Get up there and get this taken care of.
State of Ohio
Okay, I will, thank you.
State of Ohio versus Tessa Hickman, case number CRA 23-250 A and B and CRB 23-251. Matthew Hudson is on deck.
Okay, and this is Mr. Morford's case. This is a case we thought she was here, but she's still. And there was an order, I see this apparently didn't happen. Order on April 24th that she get $20,000 with ankle monitor. That must have says cash or surety, but it must have meant OR.
Actually, we did,
Was cash or surety?
yes. And I think that we had a discussion about the fact that she thought she could post that.
Okay. All right, Ms. Hickman is appearing by teleconference. Her attorney, Mr. Morford's here in the courtroom. How do you wish to proceed?
Judge, she was assessed by Bethesda and the need for inpatient treatment was real. She has a West Virginia Medicaid. If we have a provider that will accept that form of payment, she's ready to go.
Well, the only one I know locally that could do that would be OVP. And I don't think they have anybody here. She has West Virginia Medicaid. Now, a lot of times they'll take them and after a few days they can switch them over, or is anybody willing to try to do that?
What about Nick? Nick not pay for?
They don't have inpatient, and they're out of state.
Okay.
Do you want me to try to call OVP and see if...
That's fine.
And Your Honor, we'd be willing to do an OR bond with GPS as long as she was also going to...
Inpatient?
Yes, and also waive to the grand jury.
Okay. So Ms. Hickman, your attorney's going to make some calls to see if he can find a place for you to go for treatment, and then we'll have you back out here after he's done that. So this case will be recalled.
Okay. Okay, thank you.
You're welcome.
State of Ohio versus Matthew Hudson, case numbers CRC 20-2750 A, B, C, and D, CRB 20-1019 A and B, CRB 20-1020 A and B, and CRA 256. Jeremy Jenkins is on deck.
Sir, are you Matthew Hudson?
Yes, sir.
Okay, you got one new case and it looks like some old cases.
What's the new, sir?
Receiving stolen property. Well, was this never served? Well, let's see, 23-256 is something from West Virginia, so that's the new case number, but it's not a charge here, it's from West Virginia, Division of Corrections.
Is it a felony?
It has to be. Okay, so you, Mr. Hudson, you have a right to remain silent. If you choose to make statements, it's all on the record and can be used against you. You have a right to have an attorney, to have one appointed. You have a right to bail and to make the state prove charges beyond a reasonable doubt. Do you understand that?
Yes, sir.
Okay, so the new charge, 23-256, is actually something out of the state of West Virginia from the Division of Corrections and Rehabilitation. A warrant for arrest and a hold order. And
For a parole violation?
yes, parole violation charge from the state of West Virginia. So you have a right to an extradition hearing on this. You have a right to an attorney to be appointed to represent you. So that's pending. Then you have old cases, 20-2750, 20-1019, 20-1020. And it looks like you were never, you were cited with these, but these have never been arraigned before. And there's, one of these is a felony, 20-1020. It's actually, it's on the file, it says CRB, but it's actually CRA case number.
What's the felony for, sir?
I'm going to, if you'll just wait, sir, I'm going to go over all this with you. Receiving stolen property is 20-1020A. It alleges December 25th, 2020 in Fayette Township, you did receive, retain, or dispose of property being a registration plate, HVQ 9180, that belonged to another person, and you had reasonable cause to know it had been obtained by a theft offense. So it looks like it was a license plate. The next case is 20-1019A. It's alleged December 25th, 2020, you were operating a motor vehicle while being under the influence of alcohol or drugs, or a combination, while having minors in the vehicle. That's endangering children. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Case number 20-2750. Alleges that December 25th, 2020 at 3:13 p.m. in Fayette Township, you were driving a vehicle while you were under the influence of alcohol or drugs, and it's alleged this would be your first offense. Maximum penalty 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty is 3 days in a treatment program, $375 fine, 6-month license suspension. You're also charged with driving with a suspended license. That's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine. You're charged with a safety belt violation. That's a mandatory $30 fine if you're found guilty. And you're charged with failure to control your vehicle because it looks like there was a crash. And that's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these charges?
Yes, sir.
Do you have the money to hire a lawyer? have a job?
Yes, sir.
What do you do?
I pour concrete for a living.
Are you working full-time?
No, just part-time right now.
How many hours a week on average?
It varies between 10 and 20.
Okay, I'll appoint counsel. Is there any lawyers here?
Mr. Morford is down there. He's on the line.
Mr. Morford, I'll appoint you to represent Mr. Hudson. What's the state's position on bond? I'm not sure he can get out anyway because of that holder from West Virginia.
And the other charges are things that have already been disposed of, or they're pending charges?
No. He never appeared.
Oh, okay.
From 2020. He was cited in the court on December 28th at 9 a.m. and that capias was issued at that time.
Did the other court have a bond that they wanted set on the extradition?
No, it's the parole authority in West Virginia.
Oh, okay. Well, then I would say a $2,500 cash insurance.
Okay, I'm going to make it $25,000. $25,000 cash assured.
Mr. Hudson, do you have a telephone number I can get a hold of you? This is much more for your attorney.
304-942-1879.
Thank you.
When did you come into the jail, Mr. Hudson?
On Friday, sir.
Okay, I'll set
No,
up.
I came in, no, sir, I came in on Monday, sorry.
Well, it's not a preliminary hearing anyway, so I guess we can set it for May. I'll set it for May 5th.
Will I have to be extradited?
That is the issue before the court, sir. That's it's the license. Well, we could set it for Monday if you want. Would you prefer it set Monday?
It's up to you, Judge. I'll be here either day.
Well, we're not going to have much information then, that's all.
No. Friday would probably be more productive.
All right, so the defendant agrees to set it May 5th.
Yes.
May 5th for pretrials and preliminary hearings.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jeremy Jenkins, case number CRB 71059. Jeremy Jenkins.
Sir, are you Jeremy Jenkins? All right, Mr. Jenkins, you had a review hearing a long time ago, June 13th of 2008, on a drug paraphernalia charge you didn't appear for, and there's been a warrant outstanding for you since then. Do you understand the charge?
Yes, sir.
Do you admit or deny that you failed to appear for that hearing? How long have you been in jail now?
For about, since Tuesday, I think.
Okay.
Tuesday, I got arrested.
How'd you get picked up on the warrant?
I'm a mechanic, and I was test driving a vehicle, and the brakes went out on it, and I clipped another vehicle, and when I sit and waited on the officer to show up, and when he ran my name, that came up.
Okay, I'll complete this by jail time, sir. So your case is completed by jail. You'll be released today. The jail time you served,
Thank you for that.
take care of it.
Thank you, sir.
You're welcome.
State of Ohio versus Jeffrey S. Ingram, case numbers TRC 23-134 A, B, and C, CRB 2393 A and B, and TRD 1733 47.
All right, you're Jeffrey Ingram?
Yes, sir.
Okay, you were supposed to be here for a pretrial on last Friday, correct?
Correct.
And you didn't show up?
No, I was working in Columbus. I called the clerk's office, and they told me to come in by this Friday or I'd have a warrant.
Okay. These are serious charges. Your attorney's already gone.
Right.
If you'd been here earlier, you could have talked to him. You haven't talked to
I've been
him.
out here for like 2 hours, almost 3 hours.
Well, he was here. Did you try? Did you know
Yeah,
who he
I went to
is?
the clerk's office and asked him, and they couldn't find it. I don't know.
He was right here in the courtroom. Okay, you give me a date in the next 3 weeks when you can be here. You're not gonna be working. I don't want any excuses. You have to be here. If you don't show up next time, you're gonna go into the jail till your case is
Right.
over.
We can do it next Friday if you want, Your Honor.
May the 5th. Now, Stratton. Let's make sure he's gonna be here then. What else we got?
Mr. Stratton here is here next Friday, Your Honor.
Okay. So May the 5th, you have to be here. Have to. No excuses. I don't care how many grandmas die, how many work things you got, it doesn't matter.
What time?
This is number one. 10 a.m. Be here on time, or otherwise I'll issue a warrant with no bond.
All right. Thank you, Your Honor.
May 5th, 10 o'clock.
State of Ohio recalls Tessa Hickman, case number CRA 23-250 A and B, and CRB 23-251. Mr. Morpham's case.
Morning. Or afternoon now. Seems like.
Yes, sir, it is.
I'm sorry to keep you waiting. I was on the phone with OVP. You were waiting on me. I've been asked to make a referral, which I guess consists of her name, personal identification, and the fact that she's incarcerated.
Are they saying they can take her?
Yes, they said that would not be a problem.
All right. So the state's agreeable to having an OR bond with an ankle monitor.
Correct.
And Ms. Hickman, could you hear all that?
Yes, yes, sir.
Are you agreeable with it?
Yes, sir.
So what I'm going to do, I'm going to let you out on your signature, but I'm also going to put an ankle monitor on you, and I have to have this speech with you because it's serious business. I mean, you've got some pretty serious charges. So if I'm going to put this ankle monitor on you, you're going to go to a treatment facility, and then if you leave, or especially if you leave and cut the ankle monitor off, that's going to trigger a whole bunch of really bad stuff.
Yes, sir.
The state looks at it the same as you busting out of the jail.
Yes, sir.
So we've had, even though I've had this conversation with a few people, we have people that still do it. So if you think you're going to be tempted to cut off the ankle monitor, just sit in the jail because you will go to prison for several years.
3 years.
3 years for cutting your ankle monitor off. So if you think, well, I don't think I can do that, I'm going to cut my ankle monitor off, you'd be better just staying in jail for a while. Because you're not going to get... Okay.
And you have to pay for the ankle monitor, Judge.
So, I'm going to order that you get an ankle monitor. Now, whether that'll happen this afternoon or Monday, I don't know.
Now, Your Honor, this is also in exchange for a waiver to the grand jury as well.
Okay, and your case is going on to the grand jury.
Okay, what's that mean?
That means your case is going to be presented for indictment to the grand jury. And you're waiving, see, I do what's called a preliminary hearing, where I'm supposed to look at it and say, yeah or no, the state has enough evidence to take it to the grand jury. That's what a preliminary hearing is, to review the evidence and make sure there's at least probable cause to think you committed this offense and bind it over to the grand jury. You're waiving that hearing and saying, I agree, you can take my case to the grand jury without the judge looking at it.
Yes.
Okay. So your case is going on to the grand jury. You're going to get an ankle monitor. You're going to go to OVP for treatment. And they'll pick you up from the jail. And then the next time you appear in court, you'll be in Ironton. Now, what happens? That's a 30-day program, and she may not get indicted within 30 days.
Can I go check myself into another rehab after that?
Well, this is the only one we can get you into right now. And that's...
She's talking about, she said after that. I believe
Well, she can, but, I mean, there's not going to be a mechanism for following her. Because it's very unlikely the Common Pleas is going to have anything up and running in 30 days.
What is the prolonged? Yeah,
20,000 or...
Ms. Hickman, do you want to speed up the procedures in getting to Ironton? We can do something that's known as a bill of information, where we waive the grand jury and agree the state can bring those charges against you. And you would not be waiting on the next grand jury, which should be at least 30 days. I know it was meeting yesterday, or the day before.
Your Honor,
So if I do that, will I still get the ankle monitor and go to rehab?
Yes.
Yes.
It just speeds up the indictment, is that what you're saying, really?
It speeds up, it's not indictment, same as an indictment. Well, no, I can't say it's the same as indictment because that's not a true statement. It's just a way for the state to bring charges by agreement. It has nothing to do with your guilt or innocence, and it speeds up the time within which the charges can get filed in Ironton.
Okay, yeah, that's fine.
Okay.
they can do that. We could also keep the theft charge here. It's a misdemeanor. And that would be a way for the court to continue to monitor her whereabouts.
Okay, I'm fine either way. Mr. Morford, do you have a preference?
Judge, I don't, whichever you prefer.
We can do both for that matter.
Huh?
We can do both for that matter.
Okay, probably a good idea, so it doesn't fall through the cracks. So I'm going to keep your misdemeanor case here. I'm ordering you to treatment at OBP, and let's come back, so maybe May the 19th, to make sure she's doing what she's supposed to and where she is where she's supposed to be. So you're going to come back at least one more time in front of me before you go to Common Pleas Court. So hopefully you'll get out and go to treatment today, or it might be Monday if we can't get the ankle monitor on you this afternoon.
Thank you, Judge, I appreciate it.
Okay, good luck, and the better you do in treatment, I think that's going to stand you in good stead down in common pleas. Get good reports.
The much better result I can get, or whoever your lawyer is in Ironton, the better you do there, the better the outcome you can expect. The key is in your hands.
Thank you, guys, I appreciate it.
Okay, her next hearing is May 19th. So somebody needs to let adult probation know we need an ankle monitor. Okay, that finishes us up at the jail.
State of Ohio recalls Christopher Call, case number CRA 23-246 A, B, and C, and CRB 23-249.
Okay, he needs to be brought out.
May we approach, Your Honor?
Yes. All right, Mr. Call, you can come down and sit with your counsel. State ready to proceed?
Yes, Your Honor.
Senate ready to proceed?
Yes, Your Honor.
Ma'am, if you raise your right hand, please. Do you swear the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God?
Ma'am, thank you, Your Honor. Could you state your name, please?
My name is Sarah Call.
Sarah?
Yes.
Thank you.
Your husband is Christopher Call, is that correct? And do you see him in the courtroom today? And if you do, can you point to him?
I do.
record will show she pointed to the phone.
You made some complaints to Lawrence County law enforcement about an incident on April the 21st of 2023 in Union Township here in Lawrence County, correct?
Yes, sir.
And I would like for you to explain to the court what happened.
The day before the incident, we had went to see Randall Lambert and Ironton to file for a dissolution. We've been married for 14 years, and we weren't happy together, so we were in agreement that we were going to separate. I went to work my shift at the hospital. I worked 7 to 7 a. I came home that morning to try to go to sleep for my shift the next night. I woke up a little while later, and I noticed my cell phone was missing. I asked him where my cell phone was, and he told me that he wasn't going to give it to me, and I knew it was going to escalate to a fight. So I was just going to get some of my stuff and go ahead and leave before it got worse. So I asked again while I was getting my stuff from my cell phone, and he told me that he would give it to me. So I said, well, I'm going to call the sheriff's office so they can be here with me so I can get some things safely and I can leave. We started to argue back and forth about me leaving. He was sitting on the bed and had his cell phone beside him. I tried to grab his cell phone to call the sheriff's office. At that time, he grabbed me by the back of my hair and shoved me face first into our bedroom wall. Still having hold of my hair, he pulled me onto our bed and began to choke me with both of his hands until my vision became black and spotty. The only thing I didn't do was to take my legs and try to kick because I knew that I had to breathe. I kicked so much, it worked me off the bed onto our bedroom floor to where he grabbed my right arm and began to twist it. And so I went belly down, face down on our bedroom floor. At that point, he straddled me and sat on my backside and held both of my hands behind my back with one of his. And I heard him rustling for something. And he was getting laces out of his boots to restrain me. And he tied both of my hands behind my back. I don't know how long I was on the floor, but while I was restrained, I kept telling him that I was in pain, that we could work it out, that I really needed to get up. Sometime later, he pulled me by my arms up to my knees and up to my feet and put me on the bed and told me he would untie me if I could calm down. And I said I just wanted to leave. He told me I could not leave because I would call the police. I tried to tell him I wouldn't. A little while later, he untied my hands, and he presented a pill to me and told me to take it. When I did not want to take it, and he told me if I did not, that he would make a cocktail for me to take. He put the pill in my mouth, I chewed it up, spit most of it back into the bed. He picked up the pieces that were in the bed and put them back in my mouth. And he told me I needed to lay down and calm down. So every little while I asked, can I leave now? And he said, you can't leave because you're going to call the police. And I told him I didn't want to die. And he said, that's for you to kill me. And he said, why would I kill you? Well, I really don't know where you go from tying somebody up and giving them drugs. So I sat there. At one point I told him I had to go to the restroom. He walked with me to the bathroom, stood in front of the toilet. After I used the restroom, he had me remove my shirt so he could check to see if he had left any marks on me. He had me redress, go back to the bedroom, lay back down, and I asked again if I could leave. And he told me no, because I would call the police. around 2 o'clock, maybe a little after, it's time to get our children from school. So my thought was, as soon as he leaves, I'll run him. But then there was my kids, and he would have them. So he went out to go leave to get our kids, and his vehicle had a low tire. So he was taking the air compressor to fill up his tire. I put on the shoes that were at the door, and I went to my vehicle. I don't know why he didn't stop me, but I went back on our children from school, and I went directly to the Chesapeake Police Department.
Ms. Call, just in case it wasn't clear before, are you married to Christopher Call?
Yes, sir.
And this happened on April the 21st, 2023 in Union Township here in Lawrence County, is that
Yes,
right?
sir.
How long do you think that this whole sequence of events lasted?
From a little before 9 a.m. until after 1:30, 2 o'clock.
And during that entire time, you were not free to leave?
No.
Did you seek medical attention?
Yes, sir.
Where did you go?
I went to Cabell Huntington Hospital by EMS. I was choked to the point that I was having difficulty swallowing, and my throat was starting to swell, and I was concerned that the swelling may get worse.
And what kind of injuries did you find out that you had?
They were just soft tissue injuries, bruises, contusions, a lot of swelling, and soft tissue damage in my shoulder.
Are you still having problems?
Yes, sir.
I think that's all I have of this witness, Your Honor.
Mr. Morgan.
Thank you, ma'am. Don't mean to make this any more painful than it has to be, and I'm going to ask you a couple of questions. Has he ever shown violent tendencies before or been violent with you before?
Yes, sir, a few times, but not to that extent.
Have you ever filed domestic violence charges against him before?
No, sir.
And you have filed for divorce, is that correct?
Yes.
And did he throw you onto the bed? Did you fall onto the bed? How did you end up on the bed exactly?
He pulled me by my hair into the
Pulled you by your hair? Yes. Were you standing up and he's standing up? Or?
Yes.
And then he tried to strangle you?
He did, yes.
How did he do that?
With both hands around my throat.
And that affected you in some bad way?
Yes, sir, that cut off my air supply to the point where I almost lost consciousness.
And did you tell me you almost blacked out? Did I understand you to say that?
Yep.
Had he been using any drugs that day, do you know of?
Not that I'm aware.
Were there some mushrooms found at your house?
That's what I was told.
You didn't know anything about those?
No, sir.
You don't know whether or not he had consumed any of those mushrooms April 21st?
Just 12 hours shifts before I was on home.
Where was it you worked?
Cabell Huntington Hospital.
What's your position there?
I'm a licensed practicing nurse.
Where do you practice?
Do you mean the floor?
What floor is?
I don't know why that's relevant.
I'm sorry?
I don't know why that's relevant.
I think that's all I have, Ron.
Mr. Hill.
We don't have anything else of this witness, Your Honor.
You may step down, ma'am.
We'll call Deputy DeLong.
Deputy, raise your right hand, please. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may be seated.
Deputy, state your name, please.
Deputy Michael Lawler from Lawrence County Sheriff's Office.
In your job there with the sheriff's office, did you have occasion to investigate the situation with Christopher Call and Sarah Call on April the 21st, 2023?
Yes, sir.
As part of this, did you have did you discover some drug activity within the household there in Chesapeake?
Yes, sir.
Can you tell the court what your involvement was with that?
Yes, sir. I was actually ground man on the SWAT team, make entry to the home where Mr. Call was allegedly barricaded and heavily armed due to those.
And that was because of the domestic violence situation that...
Yes, sir. Okay. Action was given. Upon entry, we had to secure the scene. There was 2 logs found in the kitchen. We were looking for the elements of the crime. We were informed that he had given her medication and allegedly tied her up with the Harley boots. Those will be further in the conduction of our investigation. As we walked through the home, looking for the bedroom where the events had taken place, I did observe a drawer open with a revolver, the butt of a revolver sticking out, and a large folded currency. It wasn't what we were looking for at the time. As we entered the home, one of the deputies on the SWAT team noticed that there was a bag of what appeared to be psilocybin mushrooms in it and vacuum sealed. At that time, I ordered everyone out of the home and advised them that a search warrant needed to be obtained.
And was a search warrant obtained?
Yes, sir. At that point, Deputy Chin stood guard of the house so no evidence could be altered, changed, or destroyed. I drove to J Rock in the village of Coal Grove. I typed up a search warrant, had it validated by a judge and signed, returned to the home, still in the original form where we left it. Myself and Deputy Chin conducted the search warrant.
And you then discovered contraband in the form of psilocybin mushrooms in the home?
Yes, there was a total of 198 grams roughly of psilocybin mushrooms. 2 of the bags were vacuum sealed. One of those were in a 1-gallon Ziploc freezer baggie. One of the bags that was vacuum sealed was located in the bottom of a gun locker where the firearms were also located. That was left open prior to deputies arriving on the scene. Inside that locker there were also scales, empty and unused pill capsules, and a small grinder with the residue of what appeared to be psilocybin mushrooms.
And the amount of the mushrooms was in excess of 5 times the bulk amount?
Yes, sir.
As far as the evidence collected of the domestic violence, strangulation, kidnapping charges, were you able to locate evidence that those things occurred?
Yes, sir, we were. In the floor by the base of the bed, there were 2 black leather Harley boots, high-top boots that lace up. One of the boots, as noted in the photograph, the laces on it had been distinctly altered as if they were recently put on. They weren't threaded through the straps, the silver buckles that are threaded through the string itself. They were obscured, flipped over in the wrong manner, and one of the boots was laced up through the eyelets, which further corroborated the victim's story.
And any evidence of some sort of a pill or medication?
Yes, sir. In the gun locker where the psilocybin mushrooms were located and the scales were located, there was a large green and clear tote. I believe it had an Easter theme to it. It had in excess of 3,000 Ambien pills of different makes and models in it. And on top of it, in black Sharpie marker, it was scribed nap time with, I believe, a drawing of a face with 2 X's for the eyes and some Z's beside it, which further corroborated the victim's story.
That's all I have for this witness, Your Honor.
Mr. Morgan.
Deputy Lawler, you found in the gun locker shrooms?
One of the bags of shrooms was in the mushroom or in the gun locker.
And 3,000 sort of pills, did I understand you say?
In excess of 3,000 pills. Bulk amount for Schedule 4, such as Ambien in the state of Ohio, was met in excess.
And what else did you say you found in there with something with eyes? I didn't hear what you said.
I can't hear you, sir, I'm sorry.
What did you say there at the very end that you found in the locker with something with eyes?
The container where the Ambien was housed was a clear container with an Easter theme on it and a lime green lid. On
Okay.
top of that lime green lid, someone had written with a Sharpie marker, what appeared to be a Sharpie marker, nap time, with a, what appeared to be a smiley face with X's on the eyes, and a few cartoon Z's coming from the head, often portrayed as when someone's taking a nap.
Write it down, I can't hear you. Did you see the shrooms before or after the search warrant?
The shrooms that were in the black duffel bag beside the bed,
Yes.
as I specified, were notated because we were looking for A, the bills that he had allegedly given the victim, and B, the boots that he had allegedly tied the victim up with. They were not obscured in any way. Deputy Cochran noticed them and said there was a large bag of shrooms. At that time, I ordered all officers to fall back so a search warrant could be obtained.
Are you telling me they were in plain view?
Yes, sir, the black duffel bag beside what is believed to be the defendant's bed.
How did the defendant seem to you? Did he seem to be under the influence of some kind of illicit substance?
Sir, I'm not going to lie in front of the court. Whenever I arrived primarily on scene, my job was to get him out of the house as safely as possible and worry about the safety of my team. I believe he might have been a little uneasy due to the fact that the home was barricaded by the front door. There's photos attached to that as well, and the amount of firearms that was laying around the house. But once he was brought out, he was secured. He made sure there was no weapons on him. We made sure that we had rendered no first aid. He was secured in an air-conditioned car. At that point, I had no more contact with him. He was secured and supervised by a sergeant that was on scene, and then he was escorted down to J-Rock by Detective Lehman, who interviewed him. So I'm not a medical professional by any means, and based off of what I've given you in information, I can only tell you that he was taken to the car.
Was he cooperative with you?
No, sir. Where the door was originally barricaded at, we had to attempt to break in to make entry. At one point, he had came from the other side of the room and pressed his hands against the door, as noted in the report. Trying to stop, we actually had to strike the door again, moving the barricade far enough for me to actually grab a hold of the defendant's right arm and bring him out the building. At that time, he was brought to his knees directly by the door, patted down for weapons and handcuffed. He has 2 sets of handcuffs put on him because we didn't know the medical extent of his arms. He said at one point that he had a bolt in his knee. He was then taken to the car, checked, and then secured.
Did he give you any kind of statement, sir?
Sir, he did not give me any statement whatsoever.
Did he give it any to any other law enforcement officer that was present that you know
Detective
of?
Lehman.
And where is the evidence that was seized from the house? Where is the evidence that was seized from the house?
Where is the evidence?
Yes.
It's currently, it is temporarily stored in the Lawrence County Sheriff's Department temporary storage facility. It'll be transferred to permanent storage.
That's all I have, Your Honor.
Mr. Hill,
Nothing further, Your Honor.
you may step down, thank you.
We were asked for that.
Any evidence from the defendant?
No, thank you, Your Honor.
All right, I find there's sufficient evidence to bind this case over to the grand jury, and I will not reduce the bond.
Your Honor, there's a misdemeanor domestic violence charge along with this as well. We'll nolly that to the grand jury.
That misdemeanor is nolly.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Gary Thompson, case number CRB 22526A and B.
They won't modify it.
All right, Mr. Thompson is here. I assume you got a call from Mr. Sowers.
Yeah, I was in Charleston working with Scotty Hutchison again, and I tried to hurry and get back here on time.
Okay, and you did pay the court costs?
Yeah, I paid everything.
All right, the case is dismissed.
Okay. Thank you.
You're welcome. That's 22-526. 22-526. Court's adjourned.
We done for the minutes?
Yeah.
Don't be tired.
Well, they're saying that
There really is no difference, but I know,
just said, what's that look at?
what? The misdemeanor is going with it, we're not on it, but they want to know, it really makes no difference. It's gonna go to the grand jury. It's-
Time I know Tony, or she went to school with my daughter.
I'm glad you did that. That's what we're here for.
Yeah. Okay, so domestic violence was way, it's not in the grant, so that's. Let me finish this one first. And get it to the goals. The kidnapping, nothing changed. It was bound over to the grand jury, correct?
Yes,
Okay.
everything else is going, I think it was all felonies with that one.
Yes. And I go to dispo with data and all that stuff, okay?
I hope I have to make about 10 trips up to the fairground tomorrow day.
No, it's a bind over.
What are they gonna do? Is that where people bring in their things they want to call off?
Yeah. All right, thank you for your time.
Some of these. Let's ask Dorothy.
Oh, I'll see you at 1:02. Oh, I'll see you at 1:02. Let's go.